Yes.
I don't make a mention.
Admission matters.
Education.
Give all admission matters. Post all admission tomorrow. Admissions. Give. Take all admissions.
But I have two after notice admission matters, but after notice. Notice had been issued.
After notice, we'll have it after the 1 week.
May I request for next week? Subject to Lordship's acceptance. Next week, because of matter relating to promotion, the others juniors have been promoted.
It need to happen. Promotion matters are never treated as urgent matters. Not after 2 weeks. 2 weeks.
My lord, matter is related to area salary.
Admission matter.
No, madam, notice is already served. They have to file the so-called.
Oh, which
Aided salary. Aided salary relating to the Utkal University.
Which year?
2017.
17.
Yes.
Post it on Monday.
My discount for service matter. I have given a memo. Monday
For admission.
and not the after notice matter.
After notice. After notice, I know. Which year?
2025.
Huh?
25.
25.
In this case, the stage continuing, I guess, to be manageable.
Post after 2 weeks.
Matter regarding regularization of service, petitioners are
Which year?
2024.
24. After 2 weeks.
Your Lordship, this is a third contempt. This is a third contempt. The order has been passed in 28/11/2022 for equal pay and equal work. The order has not been complied till yet. This is a third contempt.
On matter, my lord, registration of marriage, my lord, has been rejected by the marriage officer.
Registration of marriage. Rejected.
Rejected.
Any urgency to get married?
My lord, for compensation.
Next.
And another matter, my lord, the petitioner completed the work, my lord, but not paid the dues, my lord, by the
2 weeks.
Pardon me, Your Lordship. Your Lordship, this is the 2023 matter, Your Lordship. The opposite parties are denying the supply of raw materials.
Next.
Yes.
Yes.
To mention me, Lord, item 15. There is, I have filed an IA. Let it come with IA tomorrow, my Lord.
Tomorrow? Today, any difficulty?
I have filed IA for stay.
Next week we'll have that. Serial number 51.
Item 15.
I may be pardoned, Your Lordship. Item 76, we are challenging the rejection of regularization of the petitioner after working 26 years as a DLR on the grounds of Uma Devi.
What do you want?
I'm seeking an adjournment on the...
Why you arguing?
No, I'm not arguing. Lordship, I'm just stating...
You want time.
I'm not...
Ask time.
Just that the Learned Counsel for the state has to file a counter. Counter has not been filed. A stipulated date may be fixed for filing of counter.
Suppose if he does not...
There are dates.
So you will wait in eternity. Therefore, take advantage of not filing it. There are 2 judgments of the apex court. Where petition arguments are not denied by the other side, court should act upon ordinarily. Prima facie what is stated in the petition. So you are telling to your enemy, no, you ask him to postpone the war because my enemy has not brought the weapon. This best use of absence of weapon. Is it done? No, wait.
Then Your Lordship may kindly adjourn it a little.
2 weeks?
2 weeks.
2 weeks. That you can say. Why you blame government for what?
76. 76.
76.
I'm great.
72, my lord, similar prayer.
And now what I have said, the other side also has understood. I may allow the petition because no objections are filed. There are such 2 judgments of the apex court where objections are not filed. The court should take like not filing the WS. Is it? So the petition arguments remain uncontroverted. On the basis of that, we may grant the relief also. When you have this in your mind.
Item 72.
72.
Here the reply not filed. I want adjournment till next week because
that only. Call week after next.
My Lordship, it's a pension matter.
That's a request of them to see the lawyers.
Lordship, it's a pension matter.
May kindly be listed next week, ma'am.
Next week, which year?
And 24.
Admission.
No, sir. Fresh admission.
Notice.
Fresh admission, sir.
Fresh admission. We'll have next week. Take that. Next week.
I may be pardoned to make a mention, Vilas. This outside board matter.
Huh?
It's an outside board matter. This is a writ petition after notice matter. Pleadings have been concluded, Milas.
Which year, man?
2024, my lords.
24.
Any day your lordship may put up any day.
After 3 weeks, we'll have.
Any day your lordship.
Okay.
As your lordship pleases.
After 3 weeks.
May I please? Item,
Give a memo. Yeah.
item 60, my lord. The 2 weeks time, my lord.
61.
60, my lord.
60.
Yes, my lord.
Okay.
And a similar core
2018
item.
matter.
Eh?
2018 matter.
Yes, my lord. Next week, petition of file additional affidavit. And copies of file to reply, my lord. And for similar matter.
Take that.
My lord, item number 5.
You should respect him.
I admit
Is it not?
I admit
No. You may not respect the court, but also respect your brother, your sister. Suppose and inform your friend also. Otherwise, he will be waiting till 4 o'clock and he will say,
No, my lord. I inform
you are here.
Yes.
Okay. At the request of both the sides, call this matter next week.
2 weeks, madam. 2 weeks.
Week after next. Along with the connected matter. That is WP number so and so signs. Yes.
My lord, item number 5. I am praying for an adjournment to next week.
5.
Due to some personal difficulties. Today, senior counsel could not.
2 weeks at the request of.
Bless me.
Item 1.
May I please?
Yes.
Here matter, your lordship can have a glance to.
See, if youngsters come and argue, to them I will give 5 grace marks. What is meant by that? That you should not ask me. But I will give 5 grace marks if youngsters prepare and come and argue the matter. And I will write their name that they have argued very well.
Yeah, enhance it to 15%.
What?
Should enhance it to 15%.
Let us see how they perform. But then a negative valuation also you should. Yeah.
Here, my lord, the petitioner before lordship prayed for in this petition with a prayer that his prayer for correction of the spelling mistake of his in the testimonials like certificates have not been entertained by the Board of Secondary Education. Your lordship can have a glance to order dated 3/9/2024. This honorable court directed.
Copy.
Yes, yes.
Yes, sir.
I have
Be done. Suppose change of date of birth.
No,
will have
it's only name.
It will have consequences. It will have many consequences. But change of name is not a big thing.
No. There is a regulation followed by the board, which says there cannot be any change in the name unless it is a clerical error.
Yeah.
So here I have only 2 objections. Number 1, he says that there's a clerical error. Number 2 is he says that a writ of mandamus be issued against me for correction of that, and he has not annexed the demand. He has simply stated saying.
Now you have a writ petition. You have understood what
Yes,
is
I have understood. This is all the objection. Let him approach and necessary orders.
The short grievance of the petitioner is as to non-correction of whose name?
It is a spelling mistake. Petitioner name.
Names of the petitioner and parents also.
Let me clarify, madam.
Clarify. Sit down. Sit down. Sit down. I have understood. Yes. Please be seated. Yes. If you stand up, I will not give dictation at all. Basanto. The short grievance of the petitioner is as to non-correction of the names of parents and the wall in the school records. First, learned counsel for the petitioner submits that whenever clerical or other errors occur in mentioning the names in the school records, it is an ordinary rule that rectification needs to be permitted. First one. Next one. Learned senior panel counsel appearing for the answering respondents opposes the petition, saying that matter is not as simple as is projected before the court, semicolon. There are certain rules which regulate correction of names of the candidates or their parents in the school records, semicolon. If appropriate application is made in terms of those rules, there will be no difficulty for considering the same favorably, provided that evidentiary material is placed in support of the claim. First, learned counsel for the petitioner is agreeable with this proposal. Next one. In the above circumstances, petition is disposed of, preserving liberty to the petitioners to make an appropriate application to which respondent?
Control of exam. So respondent number 1.
To the first opponent, OP, something like that. First OP number 1. Seeking correction of the names, and if such an application is filed, the same shall be considered by the OP number 1 within a period of OP number 1, and result of such application shall be made known to the petitioner within an outer limit of 2 weeks. 3 weeks. First one. Next paragraph. In the above, their own sentence you can say, this is a happy thing to happen in adjudicatory process. Next paragraph. In the above circumstances, and with the above undertaken, the counsel given on behalf of the answering respondent, petition is disposed of, keeping open all contentions of the parties. Next paragraph. It is open to the answering respondent to solicit any information or document from the side of petitioner as is required for due consideration of the representation in contemplation. Semicolon. However, in that case, delay shall not be broken. Now, no cost. Any other order you want?
Yes, that is the best order which I.
Yes. Yes, what is that representation?
The representation is to keep her daughter to a safe childcare institutions, as the petitioner is a houseless and he has having no house at all, and also he is handicapped, and as the daughter is a meritorious student, and after class 8 of her, the petitioner as the father of this daughter has approached to the concerned child welfare committee of Bhadrak, and praying that the child is under CNCP, the child need for care and protection under JJ Act. To do for something for this girl, but the concerned CWC had not listened anything, and after that the handicapped father, as begging and by collecting some money, he keep her daughter to a semi-private hostel at Betada, and a social organization Samyak Samanata is also having some financial assistance to her. But the government authorities are not listening anything, and if any time these the social organizations will stop the financial assistance of this girl.
Where is your representation? Page number? Annexer?
Annexer 1, my lord, page number 10.
To read it. It's in your language, which I will make mine also in the due course. Read that.
निवेदन एक मु संजय हुई ठिकाना खपरपदा शहीदनगर ब्लॉक धामनगर जिला भद्रक मोर झीर नाम लक्ष्मीप्रिया हुई गत 2 वर्ष पूर्व एक सड़क दुर्घटन मोर मानसिक शक्ति हराइबा सहित मोर 2 हाथ एवं गोड़ विकलांग हो जाइछि एवं मु मोर परिवार को पोषिबारे संपूर्ण अक्षम तेणु मु गाँ गंडर भिक्षावृत्ति कर चलुअछि एवं रहिबा पई मध्ये एक घरटिए नाही आम्भे सपरिवार खपरपदरे एक अंगनवाड़ी केन्द्र रे रही आसु मोर एई अवस्था पई मु मोर झीर खाइबा
What is his prayer? You understood now?
Yes, sir.
Why can't you consider that?
Yes, the representation has been filed before the opposite party number 2. That is pending.
Who is your client?
Yes, Child Welfare Committee, Bhadrak, through chairperson, So if your lordship,
Both the child is handicapped or parent is handicapped?
Parent is handicapped.
Parent is handicapped. Handicapped means what has happened?
She has faced a accident before 2 years, and so that his one side mouth and hand are not working, and so that
No compensation given in MEC matter.
now she is some 5,500 na 700 allowances per month he has given.
No, but you said that it is accident. Did you not put forth claim under the Motor Vehicles Act? For compensation. What if
No, my lord, the petitioner has not come to any compensation at that time. But at the child is concerned, she is now in a minor girl and having age 40 to 15 years.
You want her to be in a hostel?
Hostel, my lord.
Whether hostel facility is available?
that I have to.
Just you verify, and then you come out. I call this matter tomorrow or Monday. Issue notice. Short grievances in one. First time. Call this matter on Monday. Issue notice.
Can I file a requisite for the issue notice?
No, not necessary. You serve a copy now. Not necessary. You have given copy now? Okay.
Obliged.
I think we
Yes.
May I please, your lordship?
Yeah.
The petitioners here applied for approval of their building plan in 2021 to the Bhubaneswar Municipal Corporation. And the annexure 1 are their property, ROR, record of rights. After application by annexure 2, the petitioner was asked to give
Certain documents.
document regarding the road. Then in exhibit 2, the inquiry was called for from the Tahsildar. Tahsildar, your lordship may kindly see annexure 2.
What Tahsildar said?
Sir, yes, there is a road, but some portion is encroached. There is a public road, but some portion is encroached. Thereafter, I filed application to remove the encroachment. Then they went to the Bhubaneswar Development Authority.
Who encroached?
Bhubaneswar Development Authority, my lord.
They have encroached.
Then Bhubaneswar Development went for eviction.
Take issue. Notice has not yet happened.
No, my lord, yes.
Issue emergent notice returnable within 10 days. First stop. This court notes that right to reside is a fundamental right guaranteed under Article 19(1).
19(1).
Which is that? You tell that.
Right to residence.
Yes.
19(1), my lord.
19(1) A, B, C, D, everything. Have you ever read Constitution?
Yes.
Then tell.
No, I do not know.
Then pass over.
My lord.
You have to assist the court.
Yes,
You have to come with that.
definitely, my lord. I have not come with the constitution. Sorry, my lord.
19(1) just locate to.
My lord.
First one. Therefore, non-consideration of application for grant of building license is a serious matter. First one. Call this matter. Who are the respondents?
1 to 6. Bhubaneswar Municipal Corporation.
Who appears for corporation?
Panel advocates are there, my lord.
Who, in addition to taking government?
I will take notice. No. I will take notice, my lord. You will my special messenger also. I will take.
Notice. In addition to taking usual steps, petitioner is permitted to serve copy of the petition on the panel counsel appearing for the answering respondents.
My lord.
item 4.
Sorry, my lord, I have not brought with the.
Because why I say this here? Others get alerted.
My lord.
If you see, we understand language of law. If you tell the law, I will work with you.
My lord.
That is the reason. Oh,
May I please, your lordship?
yes.
I beg your pardon. Item 4. This file was before the previous council in a court.
You are not yet.
Yes, your lordship may call it Monday.
Monday we have posted many matters. Tuesday we
Yes, obliged.
follow on Tuesday at the request of learned AG who pleads some difficulty.
Yes. Intimated to contact.
You have intimate? Yes. Then I will call it after 2 weeks, 4 weeks.
Yes, ma'am.
Call after 4 weeks at the request of. I was under impression there was no intimate. interim order to continue till next date of hearing.
What was
Yeah,
item 6?
right, one sentence, heard, learned advocate, so and so, and learned AGA appearing for the respondents. Thereafter, interim order to continue, interim order granted by coordinate bench.
Yes.
Granted by the coordinate bench is continued.
Dated at 26 2025. 20 June. 20th June.
2024 is continued till next date of hearing, columns matter after 4 weeks. That's the request of government AGA. Yes.
Item 6.
May I please? In this case, the petitioner wants to change his father's name in +2 certificate, my lord.
Father's name,
My lord.
PUC certificate.
My lord. Council certificate. +2 pass.
Why you want to change father's name?
My lord, his mother married second time.
But you continue to be father only.
My lord, the biological father's name has been deleted from the certificate. That's why by under Annexure 6, this Honorable Court directed to correct the 10th certificate. And accordingly, the 10th certificate was corrected and issued to the petitioner. Likewise, the in +2 certificate, his biological father's name has not been incorporated.
Who appears for the respondent?
Opposite partner 2 is to be correct. The
AGA issue emergent notice. AGA on request appears for response number 1. Original or the CBSE.
minor.
Yes, the grievance is against the opposite party number 2 and they are having own panels.
Issue emergent notice to OP number 2 and 3 to it, returnable within 10 days. If it is to be for immediate.
Item 7.
Yes.
This is a second round litigation, my lord. Here, the petitioner approached this Honorable Court earlier by filing a rate petition bearing WBC number 7808/2021 under
And the A is impugned order.
Yes, ma'am.
What does it say?
Yeah, they rejected my claim.
Your library attended.
Yes, they rejected my claim on the ground. His service was regularized after 115, so he is not entitled to get pension under OCS pension rule 1992.
How many years of service you have put?
The initially appointment given to the petitioner in the year 1991.
91.
Yes, and under Annex 1, my lord.
Annex 1.
Yes.
Their version is you have not put in qualifying service.
Yes.
Because qualifying service is to be reckoned from the date of regularization of service.
Yes, ma'am.
Suppose if you will not regularize for 30 years, then when he is going to retire next week, he will regularize the service now.
No, it is the grievance is against the opposite party 1 and 2.
Issue emergent notice.
Yes.
Learned AGA appears for
3 and 4.
3, 4.
Emergent notice to 1 and 2. Learned AGA appears for response number 4. Because that rule which we have interpreted in the division bench, ordinarily from the date of regularization, it should be counted. But suppose if the regularization is delayed enormously because of your fault, why employee should lose the pension, having worked for 3 decades? So just look into that. You get that division?
In similar matter, your lordship issue notice tag in this.
Tag this matter to WP number so and so. Along for 2 weeks, 3 weeks. We finished to be furnished immediately.
Chancellor is the not necessary party, I think. Now, opposite party number 5.
5. Not necessary.
Not necessary. Chancellor is the governor of Orissa. He is the chancellor.
Why governor is, you want to?
As for statute, the chancellor is the
Operator.
yes.
Every governor will be the chancellor of every university, ordinarily in every state. Let us.
Item 8.
My lord, I may be permitted to place on behalf of Mr. Nayak, my lord. My lord, petitioner was engaged as appointed as a peon in 1991
91.
91, my lord. As a peon, my lord. His appointment was approved in 1997 against 4th post of peon, my lord.
97 appointment approved and he became the regular employee.
Regular employee, my lord.
Or contract employee.
Regular employee.
Regular employee.
But what has happened, all of a sudden my salary was stopped and a dispute arose. The appointment to the 4th post of peon is not correct because as per the standard staffing pattern of a high school, there are 3 posts of peons are there: office peon, science attendant, and night watchman cum sweeper. Another post is there for daftari. And daftari is being a promotional post, and after if roll strength exceed 100 and subsequently it has enhanced to 500, a daftari post is admissible. So out of 3 posts of peons, one post of peon can be promoted to the post of daftari, and the 4th post will be adjusted against 3rd post of peon. But this dispute was arose by, and this Honorable Court decided in case of Rajendra Kumar Das, and matter went to this Honorable Appeals Court. Appeals Court decided a part judgment that since a person has been appointed against 4th post of peon, even though without promoting any person to the post of daftari, direction was given to managing committee, you promote a person out of 3 persons to post of daftari and adjust the person in 3rd post of peon. And 3 months time was given to the management, my lord. That was not done, my lord. In 2008, on 29th of March 2003, judgment was passed. In 2008, my lord, government took a decision to implement that judgment of the Honorable Appeals Court.
It has taken early decision.
Thereafter, my lord, some disputes are there, my lord, because thereafter petitioners and
let notice go.
Yes, my lord.
Notice issue. Emergent heard advocate Sri so and so on behalf of counsel on record. The case is made out for issuance of emergent notice. First, issue emergent notice. Subnet AGA on request accepts notice for respondent.
Yes, my lord.
Who's got copy of the petition?
You should call it a porridge or two.
Item 9.
May I please?
Yes.
My lord, the petitioner is a retired librarian working in an autonomous college. Now he is claiming pay revision in terms of the notification issued by the Department of Higher Education, that is under Annex 6 at page 23. Lords.
Similar matters, what any of other judges have
my lord. Coordinate bench has disposed of with a direction to file a fresh representation.
Oh, we'll make that. All right. But petitioner is not.
Similar order is with.
Who appears for the respondents?
State government.
Only state.
Only state.
Heard. That advocate appearing for the order. Give him copy. If you do not give him, how he will do it?
No, copy is with him. But he is asking for order.
Yeah, you are relying. You have to share copy with him. Heard that the counsel appearing for the petitioner and Lord AGA on request appearing for the respondents. Next one. Short grievance of the petitioner is as to non-extension of certain benefits post-retirement in terms of government notification dated 3/4/2023, a copy whereof avails at Annex 6. First. Next paragraph. Learned AGA appearing for the respondents opposes the petition, contending that to seek a writ of mandamus, demand of action is a precondition, and in the absence thereof, writ petition is not maintainable. First, in reply, learned counsel appearing for the petitioner places on record a copy of a coordinate bench decisions wherein liberty is reserved to the litigant of the kind to make appropriate representation, and if made, that would be considered in accordance with law by the answering respondents. First, that decision is in WPC number 5443 of 2024 between Kalpana Tirkij versus state and others, disposed of on 11/3/20. First, for granting this innocuous relief, there cannot be any objection. First, next one, in the above circumstances, and with the same terms as are mentioned in the coordinate bench decision, this petition will also disposed of in all contentions. First, petitioner is permitted to make an appropriate representation, and if the same is made, the answering respondent shall consider it within 8 weeks.
Yes.
And inform result of such consideration to the petitioner within 10 weeks. No question.
Item 10.
Yes.
I lost. Actually, it's seeking for RSCP benefit. It's similar.
Similar matters are
Yesterday matter 20, item number 27.
Fourth issue emergent notice, learned AG on request accepts notice for the respondents. First, similar matters are posted on 4th of August 2025. First, therefore, call this matter also on that day.
Much obliged.
Item 11.
In this case, I have filed this writ petition for grant benefit to the admissible post for the post at the time of admissibility, that is 1/6/1996. Similar order has been passed by this honorable court, and the case was preferred and deed of appeal, and this that deed of appeal raised by the honorable court.
You take notice.
My lords, its representation is pending.
Will that be considered,
Representation, what you have sought for?
Same benefit may be granted within the extent to 1/6/96.
What is that benefit?
Benefit, my post has been approved on 2015. Date of admissibility is 1996.
Heard, learned the appearing for the petitioner, Mr. So and so, and learned EGA appearing for the respondents on request of the court. First, the prayer of the petitioner is innocuous, and the subject matter of the petition is substantially similar to the one in WP number 4847 of 2025 between Jairam Pradhan versus state and others, disposed of by a coordinate bench of this court on 18/2/2025. Next paragraph. Para 7 of the paragraphs 5, 6, and 7 of the coordinate bench decision reads as under. Next paragraph. In view of the above, petitioner being similarly circumstanced, the petition is disposed of with in the same terms and conditions. First of all contentions are kept open. Disposed of the same terms and conditions of the coordinate bench decision. Without this. No cost.
11, 12, 26, and 37.
Same.
11, 12, 26,
26,
and 30. 30.
And 30. 30. Okay. Learned Secretary's order is upheld. In writ appeal?
I have a rate appeal number 350/2024.
This judgment is in the above.
Then in this,
the other
concern.
Yes.
I'm challenging the order of rejection. Earlier petitioner approached this honorable court. Petitioner was appointed as Shiksha Sayak. paid for regularization with effect from 2008 since similar benefit has been extended to similar situated persons. Petitioner was regularized in 2013. This 13.
When he should have been regularized?
2008, as has been extended to other persons, other equal circumstances persons.
They were appointed during your time only. They were appointed.
Along with in same time,
the same time.
2001. So they had to, after 6 years, they had to be regularized. So according to their regular 2008, 1/4/2008. So
they have done it subsequently.
That
period will be.
My lord, this one will go directed for consideration. Now they have rejected.
Issue emergent notice. Learned AGA is requested to accept notice for the respondent. Give him copy.
Again.
Okay. Small matter it is. I'll have it after 4 weeks. Not AGA. After 4 weeks, can I have that? Solve this matter after 4 weeks. Since it lies in a narrow compass.
14. Then I will make kindly pass over, my lord. After
pass over.
15.
This matter relating to extension of UGC pay scale. We have already admitted.
Sorry, my lord. Item 16, my lord. Item 16, my lord. Sorry, my lord, I am appearing.
You are appearing.
My lord.
You have objection for issuing notice.
My lord, my representation under Annexure 4 is...
if that is considered sufficient.
Yes, in light of Annexure 4, 5 and 6, my lord.
4 is to whom?
4 is to, my lord, is before Director of the Higher Education, my lord.
If that is considered sufficient.
Yes, my lord.
All contentions kept open.
Yes, my lord.
What do you say?
Because they are extending the UGC scale. Recently, they have extended the UGC scale of pay to the similar footing matters. Annexure 3, Annexure 4, my lord.
Page in the light of 5 and 6.
5 and 6, my lord.
What is that benefit you have sought for?
The reader, the petitioner is a retired reader. She was getting state scale of in the state scale of pay. Her prayer is for grant of UGC scale of pay in terms of the, my lord, the guide.
Heard Learned Counsel Shri so appearing for the petitioner and Learned AGA on request appearing for the official respondents. First, next paragraph. The short grievance of the petitioner is as to non-consideration of his representation dated
25/5/2020.
25/5/2025, wherein he has sought for extension of UGC scale post with effect from her initial appointment. As per the resolution, government resolution dated resolutions and a coordinate bench decision in WP number 20728 of 2019.
My lord, that is 2012.
But
inadvertently, my lord, that is an inadvertent typographical error, my lord.
To make the rectification. Well, as affirmed by the division bench in writ appeal number 627 of 2019, disposed of on 14/12/2022. That 27/3/2019 has written 27/3/2012.
27/3/2019. The WPC number is 20728 of 2012.
20728 of 2012.
Yes.
Dates are correct.
Dates are correct, ma'am.
Date is 27/3/2019.
19. WP. For writ appeal. Why are you taking out before I complete the reading? Yeah. First of all, he also prays for payment of differential arrears within a stipulated period. First, next. Learned AGA appearing for the answering respondents does not much dispute that the subject representation is still pending on the file of jurisdictional authority. First off, with grace, comma, he submits that if a reasonable period is prescribed, comma, there would be no difficulty for considering the subject representation in a time-bound way, provided that all contentions are kept open. First one, with this proposal, counsel for the petitioner is agreeable, comma, rightly, first one. Next paragraph. In the above circumstances, the petition is disposed of, fixing a period of 8 weeks for consideration of the subject representation at Annexure 4 in the light of Annexures 5 and 6. 6. And to inform the result of such consideration to the petition. First one. Next one. It is open to so to solicit, etc. Put that condition. No cost, petition is good.
Item 17.
May I please, my lords?
Yes.
The petitioner is a Hindi teacher receiving block grant since 2015. 2000 Annexure 10 page 32, government decided to extend TG scale, trend scale to Hindi teacher having the qualification of MA in Hindi or equivalent.
MA in Hindi equivalent.
That is page 32. Accordingly, proposal submitted by the headmaster.
Annexure 10.
Annexure 10, page 32.
Okay. Then what happened?
Cut-off date is 16 2020. The director from the date that before the date those are passed the MA in Hindi, they are entitled for digit, but trend scale.
There is a cut-off date.
Yes, cut-off date from the date. This is from the date of notification.
From the date of notification.
My lord, that is page 32, Annexure 10. Accordingly, this proposal submitted by the headmaster to the opposite partner 3. No action taken. I approach my lord in the earlier case. By representation that approach my lord. This honorable court in Annexure 14. Page 43.
14, page 43.
About taking all the consideration, directed the opposite partner 2, being the higher authority, you finalize the matter.
You consider that.
Consider finalize the matter.
Yeah.
Opposite partner 2, again Annexure 15, government directed to extend the benefits to all the Hindi teacher, not all the teacher, all to all. Those are acquired the common qualification. Page 45.
Yeah.
Director on the Annexure 16 came to a finding that I am entitled after very hot records.
Who says you are not entitled to now?
Now the opinion of 3, instead of releasing benefit, direct opinion of 3 to take a decision again. That is my lord, page 47, last paragraph.
Who has to take the decision?
Decision taken by the opinion of 3. He did not take any action. I approach my lord. My lord directed the opinion, higher authority opinion of 2. You to consider and found that I am entitled, but instead of giving again directed the opinion of 3 to consider again. For that process, this is third round litigation.
Yes,
please the matter.
Why
My lords,
being like this?
my lords,
How many times a poor person should come to the court?
Third time this is one.
my lords, the director directed to verify the documents and extend the benefits.
Within what
It
period
is-
you will do it?
My lords, it is
No time
Not,
limit.
No, you can. Within what period you are to? In fact, fault lies in us in not prescribing the period. We have fixed the period.
This one had fixed period. Fixed period. Director within the period decided, no, not decided. I filed a contempt. After contempt, he decided I am entitled, but again directed the opinion to examine the matter. How many times they will examine matter? Once they found I am entitled.
my lords,
Notice
my lord.
and next day,
4 weeks time may be granted.
4 weeks. Why 3 weeks you do that? Issue lordship. Emergent notice. Learned AG request accept notice for the respondent. All respondents?
Yes, yes.
All respondents. First of all, this is the third round of litigation. First of all, there is scope for arguing. There is scope for doubting the version of the opposite parties. First conflict. Next paragraph. In view of that, call this matter after 3 weeks.
So fixed date, my lord. No date, my lord.
Yeah, no, date admission time, we should not give the date.
My lord.
It gives wrong impression to the
Your lordship.
3 weeks, after 3 weeks. We may direct the appearance of that after hearing them. I will direct appearance of the officer. Let he or be seen by all friends. That should happen for that. Otherwise, nobody will bother nowadays. Others.
May I please, Your Lordship? My Lord, in this case, the petitioner was initially appointed as a guest faculty, Your Lordship, at Dharanidhar University under the Department of Higher Education. Then, my Lords, by a common order, the petitioner and other similarly situated persons were disengaged from their service without any opportunity of hearing. Thereafter,
wait. Let your friends complete their discussion. Then you can argue. Sorry, sir. We'll recall your order now. Yes.
At Annexure 5, by a common order, Your Lordship, the petitioner and other similarly situated persons were disengaged, Your Lordship, from their services without any opportunity of hearing. So thereafter, this Honorable Court at Annexure 6, my Lords, directed the petitioner and other persons to make a representation. Now, Your Lordship, at Annexure 7, Your Lordship.
You made the representation?
I made a representation. At Annexure 10, Your Lordship, what happened was that the previous registrar directed that we should be reinstated. However, the present incumbent registrar at Annexure 11, he has rejected our representation for reinstatement, and in a similar matter, Lordship, the Honorable Coordinate Bench has issued notice.
Notice?
Yes, Your Lordship.
Are you still in service?
No, Your Lordship. I not in service, Lordship. I was disengaged without opportunity of hearing, my Lord.
This is purely contractual for a particular period.
But your registrar said continue.
My Lords, and what he has challenged the advertisement, my Lords.
Not the advertisement, Your Lordship. What has happened is initially we were disengaged.
Let us see. Yes. All respondents. Lieutenant AG, on request of the court, accepts notice for the respondents. First up, matter lies in a narrow compass.
My Lords, opposite party number 3, Your Lordship may issue notice.
Subject notice to respond.
3, 4, and 5.
3, 4, 5. Yes. You appear for 1 and 2. Yes. You appear for 1 and 2. Emergent notice to rest of the respondents, opposite parties, returnable within 3 weeks. Call this matter along with WP number.
Yes, Your Lordship.
20048/2025.
Grateful, Your Lordship.
19.
May I please, Your Lordship?
Yes.
Well, the petitioner filed a data application challenging the illegal action of the opposite party, more particularly opposite party number 3, not a reconstitution of the managing governing body. The proposal was sending to under Annexure 3, my Lord. Page 21.
You have sent a proposal seeking reconstitution of the committee.
Constitution of the governing body. Yes, my Lord. My Lord, I will say come to the page 21. Annexure 5 series. That was sent on 13/1/2025 to the Director, Regional Director of Education, Odisha, Unit 2, Bhubaneswar, Odisha, Constitution of the Governing Body, Mahashala Sanskrit Mahavidyalaya, Airport, Pakot, Bhaya Danpur, District, Kendrapada.
What they have said?
Till today, they have not constituted the governing body. So I
further consider representation for constitution of the governing body.
My Lords, Annexure 6, Your Lordship kindly see.
Similar situation.
Accordingly, the constituted governing body, so proposed as per the details given below, shall function with effect from 5/6/2025 for a period of 3 years.
Yeah. After that, you have to reconstitute.
Well, let's see, it is constituted.
Constituted?
Yes.
6/6/2025. What is the order for that? Go to Annexure 6, which learned AGA is pointing out now.
My Lord, other college, my Lord.
Not this college.
No, my Lord.
Oh.
In terms of that, you have to, you can consider and take a decision as to why you are not approving. In fact, your rules provide for the constitution.
My Lords.
Petitioner Education Institution is knocking at the doors of the court, grieving against non-constitution of governing council in terms of which rules?
The college, the governing body of the state college in terms of the Odisha Education Establishment, Recognition and Management of Private College Rule 2020.
Which page?
Annexure 2, my Lord.
Let's see that.
Annexure 4, my Lord.
4?
Yes, my Lord.
4. First, next paragraph. Learned counsel for the petitioner drawing attention of the court to the said above rules, submits that a proper governing council is essential for the administration of the institution, and the absence of governing council would pose its own difficulties. So first, he further submits that despite furnishing all the requisites, no decision is taken by the answering respondent in this regard, and therefore this court should come to aid of the petition. First, next paragraph. Learned AGA on request appearing for the respondents, although agrees that in respect of other similarly circumstanced institutions, governing councils have been reconstituted, there appears to be some difficulty as to why that has not happened in the case of the petition. First, he agrees with the suggestion of this court that an appropriate decision in this regard would be taken by the jurisdictional respondent OP within a period of 4 weeks and in accordance with law. First, sorry, that is
considering the proposal sent by the governing body on 13/1/2020.
Keeping in view the proposal sent by the petitioner institution, wide Annexure
5 series.
Annexure 5 series.
Dated 13/1/2025.
All dated 13/1.
Yes, ma'am.
All dated 13/1/2020. First come. This is appreciable. Next paragraph. In the above circumstances, petition is disposed of, fixing a period of 8 weeks for accomplishing the task, and also to inform result of such accomplishment to the petitioner. First, all contentions are kept open. Next paragraph. Non-adherence to timeline may result into levy of heavy costs personally payable by the officials concerned at the next level of litigation. First, no costs.
Item 20.
Good, item 20, inadvertently, I have left one judgment of this Hon'Ble in my chamber for wrong. One judgment I have brought it. Well, this is the case in the second round, is a rejection.
Rejection
the claim of UTC scale of play to the demonstrators in the colleges. That has been allowed by a judgment of this Hon'Ble. This was the original judgment.
For others already such
yes, all
granted.
Yes.
Let him take notice and come back.
Fine.
Issue emergent notice. Learned AG accepts notice for all respondents.
Well, the college,
Lord,
I have to
three
take
is
college, I have to take
notice will go.
3, I will take notice.
1 and 2 you will appear.
Yes.
Well,
Emergent notice to response number 3. Okay.
Item 21.
Yes. Let me stop Pradhan. Nobody. What is the case about? First row, let us see. What is this matter?
This is regarding the revision of remuneration of the PGT scale. Let notice go.
Issue emergent notice. The AG is requested to accept notice for
OP number 1 to 3.
1 to 3. Only 3.
Yes, ma'am. 1, 2, and 3.
2 and 3.
Of course, 3 may be given because he is the principal. 3 may be
1 and 2 you appear.
1 and 2.
Will issue emergent notice to R3. OP number 3. Yes.
Item 22.
May I please, madam? Appellant is appeared in the 2025 intermediate exam +2 science and applied for a re-evaluation of his.
Because many students will be sitting, interns will be sitting. They want to learn from you.
Evaluation of his 3 papers: chemistry, botany, and geology. And he has paid the requisite fees on
Revaluation.
my lord.
Where is the provision for revaluation?
My lord, this is the government notification.
There is a provision for revaluation.
Only drawback here, my lord, I have
Recounting or revaluation?
Re-addition.
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 Revaluation is
Not permissible.
Re-addition.
Re-addition.
this can be re-addition means 5 questions are there.
Ah.
So out of 50 marks, if at all somehow it has been added 5 marks, but this has not been counted or computed while summing up this.
This is recounting.
This
Recount.
recounting,
Recounting
re-addition,
again,
this.
taking the marks.
Only drawback here, my lord,
Revaluation is not.
no, sir. I have made representation.
Provided. Then revaluation.
I have made representation a little late, my
Your
lord.
voice is not.
My lord,
no.
on this I have appeared little late, my lords. Means,
Little late means when you are.
representation, my lords, on 7/7/2025.
7/7/25.
The deadline is 18/6/2025.
Then nothing can be done.
Well, so only to consider, my lord, it's skipped
No.
my representation, my lords.
So when cutoff date is done, it will have many consequences.
Well, I have already paid on time, my lords. Because of my, due to faulty mobile phone, I have not downloaded the answer script and made a complaint before the authority.
Mr. Monty, but once we say, consider, that amounts to killing the deadline. It will have many consequences.
My lord,
Other advocates
My lord,
will tomorrow.
without going into merits, my lord, they can, my lords, my representation is kept pending. They have not,
You have made that representation only on 7/7.
my lords.
The cutoff date being
18/6, my lords.
18/6.
Yes.
Yes, nothing can be done. There are judgments.
8-7.
8/7.
8/7.
Not even
8/7 8/7 is the receipt, my lords.
No, you have made a representation on 7/7.
7/7.
But by that time, deadline was over.
My lords.
There are at least 2-3 high courts have
My
held.
lord, I have personally appeared. They have, they intimated that they can consider only by.
No, we cannot do that because this becomes a precedent for your state in all cases. Today you are saying 7/7. Another person comes 7/8. If you are given for 7/7, why do you not give me on 7/8?
Your lordship may pass only they either accept or reject, my lord. That is up to that, my lords.
Petitioner is grieving before the court against non-consideration of his application dated 7/7/2025, wherein he has sought for addition for retotaling of the marks awarded in the higher secondary examination.
Yes, my lords.
In the higher secondary examination. First, learned counsel for the petitioner argues that once a representation is taken, made, the concerned authorities have to take a call on that, this side or that side, and that having not happened, this court should intervene in the matter. First, next one. Learned AGA appearing for the answering respondent.
Here, my lord, in fact, there are panel of lawyers of the +2 higher secondary.
For government, you are appearing.
Yes, I
AG.
think government, but otherwise they have the panel lawyers.
It's not right. Any panel, I will say that first respondent, you are appearing for first respondent.
The Chairman Council of Higher Secondary Education.
You appear for him.
We can.
Yeah. So this is that respondent that will be appearing for chairman. Points out that in matters like this, there is a deadline fixed, that is 18/6/2025 for seeking relief of the kind. And once that deadline expires, nothing can be done in the matter. First time. This court broadly agrees with this position. Next one. In the above circumstances, petition is disposed of. First. However, this order does not come in the way of petitioner seeking remedy elsewhere in accordance with law. In that connection, all contentions are clear. No cause. Yes.
Item 23.
May I please, Your Lordship? May I am virtual mode.
In this matter, brother?
23, it is in respect of the disengagement of the person who has remained unauthorized absent for more than 5 years. The impugned order is at Annexure 8, my lord, for a moment,
Yes.
page 26.
Call of proceedings. One appears for the petitioner, call of proceedings.
Lordship,
Yes.
I am appearing in this case on behalf of the petitioner, Lordship.
You want to argue? Yes, give that.
Yes, my lord.
Sorry.
This disarrangement order, Your Lordship, has never been followed by principle of natural justice, Your Lordship. What happened, Lordship? I have sustained prolonged illness, Your Lordship. And that has been intimated to my school. I am a peon of the school. I engaged under rehabilitation assistance scheme, Your Lordship. So while I am continuing my service, Your Lordship, by the time I sustained illness and I intimated my illness to the authority, thereafter, Lordship, when I became fit and submitted my joining letter, then it has been stated that why we have been remain absent and asked me a show cause. I filed my show cause, Lordship. That show cause, Lordship, a glance that is under Annexer 7, page 24, Lordship. So after my show cause,
When did you disappear?
they stated, Lordship, I have been remain unauthorized absent, Lordship, from 29/6/18 to 2010/2024, Lordship.
No, how long you remained absent?
5 years, Lordship.
5 years. Yes, what is the explanation for that?
My explanation that was that I am suffering illness and filed medical certificate before the authority.
What is that?
So goes.
What is that illness?
Osteoarthritis, Lordship. Osteoarthritis.
I read in biology, the frogs go for hibernation for years. Perhaps your client did that. After 5 years, you mean to say that post should be kept vacant and we should.
Lordship, at glance, I sustained illness for osteoarthritis concern, Lordship. It is a prolonged treatment is necessary for recovery.
You be there only. Your institution cannot run that way.
No, thereafter, Lordship, I have been, after recovering, I filed my show cause and thereafter, Lordship, they have to consider. However, they placed me before the board and the board stated that my certificate is genuine, not genuine. Thereafter, they have to ask me a show cause, Lordship. Instead of giving show cause notice, how they will make discouragement, Lordship.
An employee in the cadre of peon remaining absent from duty for a long period of 5 years with no plausible explanation cannot be granted any relief at the hands of Supreme Court. First petition dismissed. Yes. Show name of one.
Item 20.
Dismissed. Yes.
Item 25 वाला खाली पास होगा. खाली पास होगा.
So, good. Okay.
In this case, the petitioner plays for a direction to the opposite party to regularize her service from the date of its joining, my lord.
When he joined?
It's joined on 29/9/2010, my lord.
Which date they have given?
But the state government under Annexure 3, my lord, page 13.
1-3.
They regularly all the full-time resource persons from the date of 27/2016.
They were appointed when?
My lord. The government fixed the date, that is 3/7/2016. That was challenged by so many petitioners in this honorable court. That was set aside, my lord. Thereafter, the government filed writ appeal. That is also dismissed. Thereafter, preferred SLT. Dismissed. On that ground, I am so many orders passed in this.
Where is your representation?
Well, my representation, though I have not filed, but made agreement in.
No, if you do not give representation, how they should know what is your grievance?
Yes, I have a filed representation, but not annexed here with me.
Do you have copy of the
Yes, ma'am. I have a copy, ma'am.
When did you say? 2620?
My lord. 6-5, the SLP dismissed, my lord. On 6-5 present. Thereafter,
Thereafter you have given it.
man.
You consider, let him give an appropriate representation.
That is
He
in-
says that he has already
our-
given.
our own-
How did you send this to him? How did you send this?
In the office of the
Where is the seal? Counter signature.
My lord, may I pray? Sir,
Yes.
let him
Make
file a
application
representation
and
keeping in view that relying upon the Niranjan Das and all other judgments. I think this will suffice.
Petitioner is grieving before the report against the non-consideration of his request for antedating his date of regularization on par with the rest of the people in the light of certain decisions of this court.
Niranjan Das versus State of Force.
Right now, in the light of decision of this court, in the light of a coordinate bench decision in the 15 numbers line, so disposed of on
29/9/2020.
29/9,
Sorry, 7/10/2021.
7/10/2021.
7 SLP
2021. See this WP, names and other thing. First, next. Learned counsel for the petitioner argues that the coordinate bench above referred to was taken in writ appeal number
Writ appeal number, my lord, 936 of 2021.
so and so, and the division bench of this court negatived the challenge. And further that matter was challenged further, and further that the SLP number
24479 of 23 million.
My lord, that SLP is enclosed, my lord, page 22.
22.
The order, exactly.
Unsupplied.
That will suffice, ma'am.
22.
Page 22.
In SLP number 24479/2023,
Along with others.
along with others of 2023. Oh, only one the matter.
This is my lord,
Many
24480.
SLPs are there.
If
na?
many
And
SLPs
other
are there.
connected SLP, which came to be rejected by the apex court, wide order dated. Where is the order?
This is dated 6/5/2025, my lord, second page.
5/2025. First up, counsel submits. Though all this has happened, the benefit of antedating with effect from the date of entry into service has not been granted after regularization. First, next paragraph. Learned AGA appearing for the respondent opposes the petition, contending that the writ of mandamus has to be preceded by demand and rejection, and that has not happened in this matter, and therefore petitioner should be relegated to making an appropriate representation to the concerned in the light of the decisions referred to above. First off, he also assures the court that should such a representation be made, the same would be considered within a reasonable period in accordance with law. First off, this should satisfy the petition. First, next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make an appropriate representation in the light of the decision cited above within 2 weeks. And if such a representation is made, the same shall be considered by the answering respondents within a period of 8 weeks next to following. First of all contentions in this regard are kept open. It is open to answering respondents to call for service.
Item 27.
May I please? Yes.
In second round litigation, the petitioner was appointed as a PET of a minority managed high school in the 2011.
Appointed as
As a PET, physical education teacher.
PET.
Madam, in the 2002, madam. That the proposal submitted by the managing committee, that is Annexure 1, submitted to management immediately 2003, but ultimately our service approved in 2011.
Your appointment is approved in 2011.
So we approve the authority to grant up GPF number because our appointment is prior to the amendment of the pension rule.
Pension rules were amended when?
1/2005. 1/2005. Our notification came in 24/9/2005, my lord. 24 September 2005, my lord. With effect for retrospective 1/5.
24/9/2005. With retrospective effect from
1/5, my lord.
1/1/2005.
We approve the authority for grant of GPF now because they are appointed prior to the amendment rules. In similar circumstances, Annexure 11 that are granted to the primary school, Annexure 11, page 32, to similar placed employees. And it's page 32.
All the 7%.
Yes.
7 plus 6, 13%.
Yes, 13%. They are also received granted from 1 for 2010, my lord. Appointed prior to that.
1 for 2010.
10. That is in the paragraph 4th line. The above employees are now working minority managed primary school and came into granted 4 with effect from 1 to 2010.
So triple benefit scheme is applicable.
Applicable to them. We are also minority managed high school teachers.
Take notice, sir.
Here notice because the rejection was there. That notice it.
There. I listened to some appeal school in this regard. Minors views that one. Yes.
Issue notice. Learned
They are entitled to the GP pension. That is latter edition Supreme Court.
learned AG
Appeals court.
accepts notice for the respondents. Any private respondent?
Private respondent, my lord, the opinion number 4 was not required. No required to issue notice. That party only.
For let that the one of the ground of the rejection that it was appointed by the management committee without adhering to the guidelines.
Issue emergent notice to respond.
5 also.
Five year.
Who had made party? To all of them.
Control government, my lord.
We do not.
Control comes on.
Yes, then.
Assume fixed date, man.
Let it come, let us.
Item 28. Yeah, please. 28 minutes that
Disturbing in the court and you're asking us to fix the date. Yes.
Here, my lord, the matter relating to grant of pension to the block grant employees. You'll also already fix the matter to
Similar.
11.
Like that.
This was fixed to September because before the division bench it was on 11/8. So I prayed for thereafter. So it was 2nd week of September.
Do you remember that WP yesterday that was posted now?
Yes, my lord. Yesterday that was there.
Which is that WP?
That I will give the number.
Issue emergent notice. You appear for whom? All respondents? No.
Except 4, my lord.
Emergent notice to respond number 4. 1, 2, 3, Mr. Mohanty. Emergent notice to respond number 4. Call this matter along with the WP number.
I will give it.
Item 39 also same.
39 also same.
Here, my lord.
Same respondents.
Same respondent on 2 are government, 3 is the private.
Respond 1.
1 is the 2 government.
1 and 2 government. Emergent notice 2, 3. Yes.
39.
Item 29.
Yes, case, my lord, I have challenged a rejection order by the Annexure 15, 11/6/2000. This on the court directed to give the attitude of promotion. The government, the opinion number 2 has rejected. My lord, in other cases, issued notice.
Issue emergent notice. Learned AG on request to appears for
all, madam. For all of the
respond.
For all, my lord. 1 to 3.
Okay. Next.
Item 31.
Arrears to be paid to you.
Okay.
Arrears.
Yes. As per tariff, according to the tariff, you will control finance and the answer 5, 6.
And just 6.
And 6.
In terms of this, it should be paid.
My lord.
Where is your representation?
And it's a 7 series, at best 20, 30.
If we direct them to consider the representation, all right.
My lord.
Petitioner is grieving before the writ court for the long pendency of his representations and reminders at Annexure 7 series, wherein he has sought for revision of service book and proper fixation of MACP benefits from actual date of appointment. First. Next paragraph. Learned counsel for, please be seated. Learned counsel appearing for Mr. Learned counsel appearing for the petitioner submits that when a citizen raises grievances through representations, that cannot be kept, the same cannot be kept pending indefinitely because of constitutional mandate enacted in Article 350. First, next. Mr. Mohan, brother, you appear for respondent.
This I am for the
Learned
all the opposite party.
Learned ASC on request appearing for the respondents, having opposed the petition initially, now agrees fairly to instruct the jurisdictional OP to take a call on the subject representations in accordance with law and in a time-bound way. First. This is operation. Next paragraph. In the above circumstances, petition is disposed of, directing consideration of representations at Annexure A7 series within an outer limit of 8 weeks, which would include intimation of such consideration, result of such consideration to the petitioner. First, all contentions of the parties are kept open. Next paragraph. Open to solicit. No cost. No cost. 32. This is 27. 31. Ah. 32. Yes.
Cumulative value of pension value.
Similar matters
value of
issue emergent notice. Learned ASC accepts notice for all respondents.
No, 1 to 3.
1 to 3. Emergent notice to private other respondents. Call this matter along with the WP number 20920 of 2025. And 20919 of 2020. In the third week of August.
So next, same.
Next also same. Same order.
Interim order. Interim order this bad.
In all these cases, in learned counsel for the petitioner submits that in identical matters, interim protection has been afforded, and therefore the same needs to be afforded to the claimant. So the principle of paying. First, they agree. Next paragraph. Interim order, as has been granted in the connected.
In respect of the recovery, further.
So far as recovery is concerned.
Item 34. For the block grant employees, at the pension matter. Similar to
we have admitted similar matters.
Yes, my lord. Your lordship, yesterday item 26.
26. Yesterday's.
My lord, that previous matter also can be
yes.
because it was in the second week of September.
Second week of September.
Okay. You were SWP, na?
Yes.
This is in item
28.
28 and 39. Today list.
Today, 28th, 39.
Yes, already Your Lordship.
But sir, directed to give the number in this.
Yeah.
Give the number. The yesterday matter, that is the.
Correct. That is serial number 22. Yesterday's list.
Yesterday, 26 minutes.
26 issue emergent notice. All parties, Mr. Monty. Mr. Monty, that is DGA, on request of the court, accepts notice for the OPs. First of all, call this matter with WP number. But yesterday is the 26.
Item 35.
For the post of principal of Orissa Adarsh Vidyalaya, the petitioner was selected and shortlisted. But as per the advertisement, she fulfilled all the criteria. Accordingly, she was shortlisted and called for document verification.
How many were shortlisted?
Out of 110, 28 shortlisted. 28.
Yes.
Shortlisted 28 and selected only 11. So finding the post are lying vacant due to ineligible, due to
Lack of required
candidates. But my prayer is, as per the conditions of the advertisement, I have fulfilled all the criteria. I belong to in-service candidate, postgraduate teacher in mathematics.
Postgraduate teacher in
Mathematics.
Any preference is there for in-service candidate?
Yes, my lord. In-service. Page 17. In-service candidate.
17.
17.
Go to 17.
Next one, 17. Experience, my lord. Principal. 2, 3. I belong to the category of 3.
3A.
3, yes, 3A, then my lord, then paragraph 3. Persons holding post of PGT or lecturer in central or state government autonomous organization of central state government in the pay band of rupees 9,300.
So they are also eligible.
Yes, they are eligible.
You take notice letter.
Yes, my lord.
Issue emergent notice. Heard learned counsel Sri so and so. Issue emergent notice. All who are all my lord. One is volunteer at the DGA on request of the court. Most the ASC, Mr. So and so, on request of the court, accepts notice for the respondents.
That's why I pray one post be rejected because
any filling of vacancy in question will be subject to outcome of the petition.
Yes,
Item 36.
My lord, in this petition challenges the inaction of the opposite party number 2, who is the commissioner of the Cuttack Municipal Corporation, authorized officer under the Orissa Development Authority Act. My prayer is the opposite party number 3 and 4 has encroached my plot number. He is the neighbor of my plot and he has encroached my plot and constructed contravening the rule 16 and 15 of the OD Act, and also the 31 to 35 of the ODA rules.
Which read the rules. You go to civil court and get removal of encroachment decree.
This is a statutory provision, my lord.
Show that.
So
when it was built?
It was built in 15 days, within 1 month.
Where have you stated?
We also, our representation was dated by 12 July 2015 to the CMC, which is Annex 4, by mistakenly written in my petition Annexure 3, page number 19 to 24.
Who appears for these authorities? Any council? No, if there is encroachment.
This is not an encroachment. This is a violation of OD Act. Development Authorities Act. And the commissioner is the authorized officer of the Development Authority Act, which contravene he shall send a special team and his Amina team, surveyor team, he demarcate the land, and if contravene, he should initiate an UC case under section 91 and 92 of the OD Act.
issue emergent notice. Learned AAC accepts notice for respondent number one emergent notice to the rest. Returnable within 4 weeks.
Item 37. Petition was that short grievance and matter relating to grant of one increment which due to the petitioner on the next day of retirement. Yesterday, item 50, Your Lordship.
Item 50.
Yesterday, item 50, WPC number 21106.
Notice.
Then disposed, you also disposed of. Representation is there. Exactly, item 50, the similar order I
The subject matter of this petition is substantially similar to the one in WP number. Studies, sorry. Item 50.
WP number 21106.
21106 of 2025. First, the said counsel for the petitioner, invoking the rule of parity, submits where a litigant is afforded particular relief in a given circumstance, similar litigant cannot be discriminated against by denying such relief. First, I agree with this field. Next paragraph. In the above circumstances, this petition is disposed of in terms of the order made in the cognate petition above, subject to same terms and conditions, without this. No cost.
Item 38.
Yeah, you appear in this matter.
Yes.
Yes.
Yes. The petitioner is a teacher, retired teacher. And after retirement, the pension sanctioning authority submitted the pension paper before the control of account Orissa. But the control of account Orissa made some objection that is under Annex 3, saying that there are some excess payment. Even if the statutory authority, here in this case, the petitioner is a retired teacher.
They want to recovery now.
Recovery and also stopping the pension, that both are there. There is Annex 3, that is the...
How much excess you have received?
I have not received. According to me, the statutory authority in exercise the statutory power granted the benefits. That is I am eligible, I am entitled. And even if that is wrong, Millard, I cannot say wrong. I said it rightly. And the authority who is my pension sanction authority, appointing authority, can recommend the case. Now the controller made this objection and said to recover. And the headmaster now right to recover, Millard.
How many years of service you have?
No, I have retired man, Millard. After retirement.
From retirement pension?
Yes, from the retirement gratuity now they are going to recover.
When did you retire?
Well, I retired to June 24.
24.
I have special date, stated the date. Exact date I stated June 24.
But FICMAC is not applicable to principal and others. Only lower cadre.
I am a lower cadre employee. I am also a teacher.
You are not.
You are a high school teacher.
High school teacher is not a lower level.
No, class 3 and class 4. That date of Punjab that is
FICMAC.
that is in respect of class 3 and class 4. And Ibn Ago is also in that Daniel Thomas too.
Officer. Group 3 and group 4.
Yes, group. Yes,
not your group. They are peons.
And
police and
clerk.
Not
Class 3 employees. I am not a gazetted employee also.
No, need not be gazetted.
But that may be, and that too.
Take notice for the to take notice. How many months they have recovered now? They have stopped.
No. They have not sanctioned the pension, and they will start with recovery. I pay the miscases they are to stop recovery.
Let us. It cannot be like.
No, they will recover in the plus.
You will get back entire money with interest. Yes.
No. In this short in this way, you'll kindly see the similar orders passed to the hard. In similar cases, they also pass these orders.
We have.
Not all orders. So the coordinate bench, case Hon'Ble.
Stopping recovery.
No, your sister said no recovery. Let's say that the entry.
Yes, brother, if it is granted, we have to.
You'll also kindly
discriminated. Which is the cadre of this man?
He's a teacher. He is a teacher and he is also teachers.
Learned counsel for the petitioner draws attention of the court to an interim order dated 10/7/2025 made by the coordinate bench of this court in WPC 18410 of 2025, whereby recovery of the kind has been interdicted. And therefore, he submits that similar relief needs to be granted to his client as well. First, this is a reasonable demand. First one, in view of the above, recovery is restrained till next date of hearing. First, call this matter along with WP 18410 of 2025 after 4 weeks. If you have already an order, we cannot discriminate because they may mistake that judge and you.
That lordship's prerogative. Interim order is not binding.
Right. Once we give an interim relief in a given circumstance, ordinarily we have to give to
Ordinarily, that's right. Absolutely.
Item 40. May I please, madam? Madam, the similarly situated candidates having similar qualifications have been allowed to take part in the process of selection for the post of assistant professor in education, whereas the petition has been discriminated. So, Lordship, kindly have a glance at page 49. 49, madam. Madam. Recruitment to the post of assistant professor, stage 1, college branch, government degree college. And it is for information of all concerned that in view of the judgment of Honorable High Court dated 27/1/2025 in WBC number 2627 of
Take emergent notice.
Madam.
Emergent notice.
Well, for OPSC, opposite part note 2, usually Mr. Hon'Ble appears for OPSC.
So I need a panel counsel. Shri Anup Behera is requested to accept notice. OP number
2.
OP number 2. For number 1, he will appear. Okay.
1.
Any similar matters admitted?
I am not in the position, but one post may reserve now. Otherwise, I will be. The process is on now. It has not been completed, so I will be deprived of.
The date, the last date has been over, my lord.
Now, after over, they have issued this notice.
Any selection and appointment pursuant to recruitment notification in question shall be subject to outcome of the petition.
Item 41.
Personal.
Item 42.
Listener's father is dead. He was a reader in English. So, during the period standard service became made and absconded. Thereafter, on basis of the order of the State Administrative Tribunal, minimum pension is given LT, lifetime area, to his son. So, my prayer in this petition is that the reader scale they have fixed in 2018. It is not in accordance with the scale of pay admissible to a reader. So they have sanctioned minimum.
No, when is a death in harness. When death occurred.
He left the service, rendered service.
His last scene is
76.
76 he entered into service.
No, entered into service 32. No, sorry. 62.
62. In 1962.
62.
10/7/1962.
10/7/1962.
762.
So, left the service 76. So died on 1/5/2013. So retirement year 90. So the pay would be revised 76 to notional fixation, 76 to 90. So accordingly the LTA.
1/5/2013 is what date?
Date of death. So they have sanctioned the minimum pension from 76 to 2013 in the minimum.
When he died, what was his last pay drawn?
Yes.
When he died.
Yes,
When
yes.
he did docket,
Yes, madam. Yes, madam. Page Annexure 13, page 43. So, as per government letter number so and so, Mr. So and so, reader in English, is fixed only 1200 in the scale of pay 1200 to 1900 with effect from 10/9/76. So, page 43. So, it would have been because
How much it would have been?
my lord, perhaps 2022, 2002.
Kindly come to 46, page 46.
Page 46.
As on 1/5/2013, 3,500 plus admissible allowances.
It is a amount of pension given. Page
Correct.
46.
Ah.
Page 46, not the scale of pay. 76.
given.
76.
What was his last drawn pay?
Yes, well, pay last drawn page not fixed. So only when I left the service, my father left the service in the year 76. They fixed it in the meager scale, initial scale of the admissible to a reader 1,200. But this is not the 1,200. So had it been revised till my retirement,
It would have been more.
yes, madam, notionally. I am not paying for pay because my father was has not entered service because of the madness. He left the service. Only the fixation of pay 76 to 90 notionally. So thereafter the 80.
Take notice, let us say, not a good case.
My lord, he didn't retire. He absconded from the service, my lord.
He abandoned the service.
Yes, yes. Your signal kindly.
My lord, Civil Medical Board declared me unfit. When the pension was calculated, they sought for the dissolved certificate. So the certificate issued by the District Medical Board, it was submitted. Thereafter, they sanctioned the pension. So everything is in, my lord, all the correspondences in the government, my lord.
Just take notice letter.
Yes, yes.
Learned ETA is requested to accept notice for respondent. All respondents.
All respondents.
All respondents, yes.
Call this matter after 6 weeks.
Item 43, made dismiss.
My lord, in this case, while the petitioner was continuing on ad hoc basis in the year 1983, he came across one advertisement, and pursuant to that advertisement, he got observed on regular basis in class 4 post, my lord, while continuing under SIT, State Institute of Educational Training, my lord.
Yes.
That is a state government aided organization, my lord. My lord, while continuing there, all on a sudden, on 29/4/13, Annexure 4, page 19, by creating a class in class, my lord, by the SIT, relocated 63 number of employees to different government organization, but abruptly disengaged the 22 number of employees, my lord. My lord,
2013,
yes, my lord. And
12 years ago.
yes, my lord.
And then what happened?
Thereafter, 20 number of employees, they approached this honorable court, my lord. My lord, that is at page
What court?
Annexure 530.
What court?
Where, yes, my lord, where there was a policy decision pursuant to closure of SIT, this disengagement, consequently this disengagement. And both closure of SIT and disengagement 29/4/13 was challenged, my lord.
What
and
happened?
Yes, my lord. Kindly have to the...
I will not have anything. You say what happened?
Yes, my lord. My lord, what happened after observing this, that there is a discrimination between this 63 number of employees and this 22 number of employees, the honorable single judge set aside the termination order 29/4/2013. But, my lord, the honorable judge granted the continuity in service and adjust the petitioner against available vacancy in respect of petitioners. But I being a class 4 employee, due to paucity of funds, I could not approach, and I have a prayer
That
before.
single judge made the order when, which day?
My lord, that is on 25/4/25.
24/5/25.
Yes, my lord, at page 32.
When the petition was filed?
Petition was filed in the year 2013.
Then you did not join the petitioner third time.
No, my lord.
Now, after seeing the judgment, you want to.
No, my lord, because here the 29/4/2013, that disengagement order was quashed. That is a judgment in vain.
Petitioners are concerned.
No, my lord, it is, my lord, kindly have a glance to that 29/4/2013
You were
for a moment. Yes, my lord.
Correct.
Along with those 22 number employees, my name is also there.
That was passed on which day?
That was passed on that 25/4/2025.
25/4.
2025. My lord, kindly have a glance to
One
page
second.
15. Yes, my lord.
25/4/2005.
25.
That's what? 25 April.
Yes, my lord.
25 April 2025.
Yes, my
In
lord.
WP number?
WPC number 10985/13, 11195 of 13, 17295 of 13.
This order came to be quashed.
Yes, my lord.
In that, you were also one of the petitioners.
No, my lord.
You were
I
not.
was not the party.
That is what I were asking you now.
Yes, my lord.
You are coming to this court
Yes, my lord.
only after seeing the victorious parties in the writ petition of 2013.
Yes.
Till then, you were a fence sitter.
My lord.
Why, after how many years we can condone
Yes,
that
my
and
lord.
delay?
Yes, my lord. I bow down, my lord. My on my humble prayer, submission before your lordship is that policy decision of closure that was also under challenge. That is also covered for me even, my lord.
You were party to.
Yes, my lord. And this 20. Yes, my lord.
You have to understand the
Yes, my
question.
lord. Yes, my lord.
That WP was which WP?
That is 11195 of 2013. My lord, all these writ petition,
Together.
there were 63 number. What happened? SIT created a class in class. SIT relocated 63 number of employees.
You take notices.
Yes.
Emergent. The AG is requested to accept notice for correspondence.
Item 44.
My lord, I am from Municipal Court, my lord. May I please, my lord?
Yes.
My lord, this is a case of stepping up in the service jurisprudence, my lord. When the junior will be getting the more pay than the senior, then senior is to be stepped up, my lord. And my junior, Kodamini Nayak, has got 49,600 and as on 30th November 2020, my lord. And she is getting more salary than. And
representation is pending. Representation is pending.
Pending, my lord.
Consideration of the representation.
Yes, my lord. Annexure 6, my lord. It is pending with OP number 4, my lord.
Yeah. Petitioner, an employee, is grieving before the court against the non-consideration of his representations at Annexure 6 series, wherein he has requested for stepping up of his pay on par with the that of an immediately junior employee in the cadre. First off. Learned counsel for the petitioner argues that in service jurisprudence, there exists a norm of stepping up the pay of a senior to make it equal to that of immediate junior in the cadre, and therefore the subject representations ought to have been considered and favored. Next paragraph. Learned AGA on request accepting notice for the OPs opposes the petition, contending that the service jurisprudence recognizes many exceptions and that the case of petitioner may be one of them, and therefore no relief can be granted. First, having so contended, now he fairly agrees with the suggestion of this court that they would instruct the answering respondents to take a call on the subject representations at an XRB series within a reasonable period and inform result thereof to the petitioner. First one, this is appreciable. Next one, in the above circumstances, writ petition is disposed of. Time for compliance is 8 weeks. First one, all contentions are kept open. First one, no courts.
Obliged, madam.
45, it is open to solicit. And you also clause na put that condition.
Item 45.
No.
Yes, sir.
The petitioner here was prosecuted and faced a trial under the provisions of NDPS Act.
NDPS.
He was convicted for 10 years with whatever fine is imposed in the judgment. Judgment was passed against him, punishment was imposed.
Conviction
was there.
And sentenced also.
Sentence.
Conviction, sentencing, fining. All three happened. When it happened?
The judgment is page 62. That is dated 8/7/2019.
8/7.
I'm sorry to interrupt, my
9th day of July 2019. No, 9/7/2019.
Oh, fine.
My lord, I'm sorry to interrupt, my lord.
Yeah.
My lord, the NCB might have the party, their copy didn't serve. That's why if my lord friend will serve a copy, then
Let us see, let him make a prima facie case, then we'll say rules.
No, in fact, it's for fresh admission.
Fresh admission.
Now, against that judgment, our client preferred an appeal before this Honorable Court.
Criminal appeal number
605 of 2019.
605
of 2019.
What happened in that?
But criminal appeal allowed. The conviction set aside.
Allowed on?
But that is on 20th of May 2024.
Yes.
Now, the point is, during the investigation stage, petitioners' bank account to the extent more than 50 lakhs were seized, then freezed, then confirmed, appeal dismissed, 68H notice issued for forfeiture.
For forfeiture, conviction is a must.
Conviction happened?
No, I'm asking. I do not know.
Forfeiture and conviction, they operate in their respective
independently.
Right, madam.
Independent.
That has nothing to do with this. Now, they operate in their independent field. Conviction is separate. Now, there is a provision under 68Z of the NDPS Act. I'll see.
Just read.
But I am reading release of property in certain cases. Where the detention of
money is also property.
That also, it's a property. Property means the bank
because
account.
there is one judgment of the apex court which says money is not property for the purpose of section 451 and 457 of the criminal procedure code.
But here under the NDPS Act, if Lordship will just let me come, subject to my Lord's permit, I'll just place it.
Yes.
Whatever is seized subject to release, post acquittal in favor of an act.
How courts have interpreted this provision?
I'm reading it, Lord, if your Lordship permits.
No, how courts have interpreted, various high courts in the country, how have they interpreted this provision?
68(2).
Yes.
68J2.
Yes.
But judgment, Lord, I don't have right to.
Just go through and come back.
Yes.
In the meanwhile, I will also go through.
But there is of course, subject to, I'll definitely go through.
Just
but can I just raise a point on which they also can take instruction?
Yeah.
Subject to my Lord's permit.
No, it's right, so that it becomes easy for him also.
Yes, they can also, to curtail the litigation, they can also obtain instruction. But the provision says, where any person referred to in clause A or clause B, clause C of subsection 2 of section 68A has been acquitted or discharged from the charges under this act or any other corresponding law or any other country, the acquittal was not appealed against, or when appealed against, the appeal was disposed of as a consequence of which Such property could not be forfeited or warrant of arrest or authorization of arrest issued against such accused has been withdrawn, then the property seized or frozen under this chapter shall stand released. There are two things. Yes. That's why I was just trying to tell your lordship. It's not the only property. Freezing of account also comes under the purview of 68. But there is a catch here. Subject to your lordship will appreciate.
What the appellate court said about freezing, non-freezing?
That there is no finding on that.
But then section says
68 says the consequence of acquittal.
Further, you read that.
Let me place it again. Yes. Where any person referred to in clause A or clause B or clause CC of subsection 2 of section 68A has been acquitted or discharged from charges under this act or any other corresponding law of any other country, and the acquittal was not appealed against, or when appealed against, the appeal was disposed of, as a consequence of which such property could not be forfeited. Such property would not be forfeited. Means it's a stage pre-forfeiture. If it is already forfeited, then the consideration may be different. Am I clear, my lord? So there to take instruction here, I am through your lordship, I am just whether this was forfeited or not.
Even otherwise, it makes no difference. Otherwise, there will be a classification which Article 14 would not admit.
That's what I was just trying to hint, my lords, so that it will cut short the time and.
Yes, who appears for the
national.
My lord, I may be pardoned, my lord.
Yeah.
Wiki number 1.
Why pardoning? What offense have committed?
No, my lord, I have interrupted.
No problem.
My lord, in wiki number 1, it has been mentioned as state of Orissa, represented by the NCD, National Narcotics Control Bureau. My lord, it will be Union of India because.
Union of India.
That can be corrected, subject to liberty from my lord.
So that senior advocate appearing for the petitioner seeks leave of the court, and the leave is granted to rectify the cost title by properly describing the first respondent. Okay. First one, counsel on record has rectified the petition.
I'm sorry, my lord, it's no problem.
Sometimes it happens. Corresponding, and state is also party, not a party.
No, state is not a party.
You are for
My lord, I'm appearing along with my learned senior.
issue emergent notice. Your senior is a senior advocate, or he can be advocate on record.
My lord, my learned senior is learned DH.
I'm appearing for the case. My CGC is there. You will collect.
Learned, are you DGCI?
DSGI.
Fine, so appears for first. Only one respondent? One respondent. Sole respondent.
They all
for this one.
NCB is the sole husband, yes.
Urgent notice, learned DGI, something said, appears for respondents. First up. Short point is involved. Now you have heard Mr. Rath's argument.
I got the point, yes. I followed it.
Some research. Yes. I expect at least senior advocates to come with research. Just reading the section will not
try to reach my lord's.
Because Apex Court said in Kusum in court,
right,
where a central legislation is interpreted by one high court in the country, ordinarily other high courts should follow it. Because in law school,
yes.
We were taught
that happens.
The judgments of court, the other high courts are persuasive in nature.
Right.
This is how we have been taught. But now law has marched further.
In case of central legislation, in case of central administrative tribunal judgments, they are applicable.
Similar.
Yes,
that's how it is.
Right. I'll definitely try to reach up to my lord's expectation.
Because other juniors should be looking at you. Your seniors should be a role model for rest of the people.
Right, Lord.
Only in conduct, but even in spending more time in the library. That's very important. Yes.
I can part actually. If the petitioner is working as an aided institution, my lord, challenging the order of the principal of the college, whereby the principal of the college, without following any procedure, decided to terminate the service on 31st, that is today.
Out of 5 matter, 4 matter yesterday also on board.
Entry model.
49. Yes, item 49. Same model.
And in this case, appeal provision is there.
Is there, but in other matters, I have already given entry model.
Right.
Next date you point out, we'll consider.
Okay. But
Issue emergent notice. Learned AG Sri requested to accept notice for the respondents. First off, learned counsel for the petitioner points out that in identical matters, namely in WP number
21053.
21053 of 2025 and other matters, this court has already granted reprieve and therefore similar reprieve needs to be extended to his client on principle of merit. First off, I agree. Next paragraph, in view of the above, entry model, as in the cognate case.
Annexure 3 mistake. Annexure 3 that
Stay of Annexure 3 till next date of hearing. Call this matter along with you entire all list.
Yes. Yesterday item 49. I'm giving us.
Yes, give that WP number so. In the first week of in the third week of August 2025. Item 47.
Maybe. Here in this case, the petitioner challenging the inaction of the opposite parties, not sanctioning the pension and pensionary benefit.
When you retire.
In this case, the petitioner joined in the year 1964. He continued till 1985. Thereafter, he was ill and no retirement notice was issued to the petitioner.
1985?
Yes.
How many years ago?
23 years. She was continuing 23 years of service.
She was put in 23 years of service?
Yes. Thereafter, so many correspondence has been made under Annexure 8 to 2000, Annexure 15. And lastly, the petitioner filed a representation before the opposite party on 1 under Annexure 16 miler to registered post, which is pending for consideration.
But 40 years you are not heard of.
He was ill, my lord. For that reason, the several correspondence has been made between the inter-department as well as the petitioner.
How that will help you?
Your lordship can see Annexure 8 minor page 28.
Correct, but 40 you have been in interaction is true. But how interaction will keep the cause alive?
Prior to this, the petitioner approached also this honorable court by filing a writ petition that was disposed of directing to consider the representation, but till date they have not complied with the said order.
Which is that order?
Under Annexure 4 in WPC OAC number 221 of 2018, page 23.
Yes, brother, 2018 WP. And in 2022, it has been disposed of.
Thereafter, one contempt has been filed, and thereafter, 1 month.
What happened in contempt?
Thereafter, 1 month of further trial was granted, but till that they have not taken any.
Okay, yes, they have filed one contempt. Order that
contempt was disposed of, granting another 1 month.
And when that it is disposed of?
2023.
23.
Yes.
But 1 month.
I will take instruction. I will take instruction whether it is complied or not.
But I will direct arrest and detention of concerned officer. I am just saying, I want one good case where in all newspapers it should come, so that the face of the government is blackened. How many you are troubling that poor lady? How many writ petitions? How many contempt you undertake? You do not follow. Call this issue emergent notice. Learned ASC accepts notice for the respondents. Call this matter next week. Next week.
No, after 1 week.
Give some data. What kind of harassment to the poor people? Unless you win the confidence of poor people, how constitution will work? Only with chosen few. This is meant for all people, more particularly those who do not have resources.
Item 48, item 46, that my payment today, the order my population. Today is the last date, 31st. Yesterday item 49 and today item.
Web order to be acted upon. Immediately. You move a memo. Is there a procedure for moving memo?
I have already applied to the certificate copy yesterday matter.
All right, you will get that.
Your website copy or my I'll upload it.
I will send you. Otherwise, you will be relieved today. Yeah.
Item 48.
May I please, Your Lordship? Lordship, in this case, the petitioner has applied for a caste certificate, ST caste certificate, for his 12-year-old daughter for admission to Jawahar Navodaya Vidyalaya into class 6th. He has applied for the caste certificate before the Tahsildar Navrampur. Your Lordship, then after she has been selected into the Jawahar Navodaya Vidyalaya by annexure 2, Your Lordship. Page number
9.
Page number 13, Your Lordship. Serial number 74. Her name is Misty Manyata Bhatra. She has been selected under through the entrance procedure into the Jawahar Navodaya Vidyalaya. Lordship, the Vatra community has been recognized as a scheduled tribe by the presidential order under Article 342. Bhatra, Lordship.
Bhatra.
Serial number 5.
Presidential order 1950.
Presidential order, Lordship, it has been written there. Under Article 342. Serial number 5, Your Lordship. Bhatra, I have underlined it.
Bhatra.
Right, Your Lordship.
All right.
Lordship. Then, Lordship, what happened was...
50.
Yes.
Yeah.
Lordship, what happened was now the Tahsildar illegally rejected the application.
No appeal on that.
Yes, Your Lordship. The appeal is pending before the collector. Appeal number 3, Your Lordship. It's supposed to be disposed of within 30 days period, and the application was made on 24th of June 2025. While it was supposed to be disposed of.
Otherwise, she may lose the select list.
Lordship.
My Lord, Your Lordship may kindly see the report of the Revenue Inspector. 5.
No. Why? It may be in your favor. Appeal is.
No, appeal is then your Lordship. Yes.
Otherwise, she may lose the seat itself. That is the reason why legislature has prescribed 30 days.
Lordship may.
3 days.
No, within 3 days it is not possible.
Why? Then within 30 days, if it does not happen.
Within 1 week it may be disposed of.
Lordship,
Then tell them to dispose of the appeal within 1 week.
Lordship, another thing is the school authority has said that unless by 8th of August 2025, the petitioner fails to provide the caste certificate, there is a court order for reserving a seat. The seat will be cancelled. So.
Why you have not made it part of the petition?
Lordship, we got it just on 25th of...
25th you got it?
Yes.
You filed the writ petition when? You filed the WP on which day? It was available to you as on the day you filed the WP.
Lordship, you got it later on.
Afterwards?
Yes. Thank you.
The short grievance of the petitioner is as to arguable long pendency of her appeal before the statutory authority in respect of an order whereby her caste status certificate has been rejected. Learned counsel for the petitioner, please be seated. Vasanto can be used for a woman also?
Yes.
I do not know.
There is no lingual difference.
No gender difference.
Gender difference, no.
Sit down. Yes, sir, brother, sit down. Learned counsel appearing for the petitioner vehemently argues that appeal of the kind has to be disposed of within the prescribed period of 30 days. Regard being had to the undesirable consequences of delay, such as losing of job, losing of seat in educational institution, or the like. First, she also has placed on record through a memo dated 31/7/2025 with leave of the court a copy of letter dated 22/7/2025, which issued by the principal of JNV Nabaranpur, which reads as one line below that. The letter reflects the undesirable consequence of the likely losing of seat by the petitioner should she fail to procure the certificate in question within the stipulated period, that is 8/8/2025. First time. Next paragraph. Learned AGA appearing for the respondent opposes the petition, contending that the jurisdictional authority functions under various legislations and therefore he will have his own difficulty in disposing of the appeal within the prescribed period. First of all. However, having so argued, now he comes out with a fair proposal that he would instruct the, which is the respondent? Answering respondent.
Answering respondent is 3.
Number 3.
Collector Nabarangpur.
3. To hear and dispose of the subject appeal within an outer limit of 1 week reckoned from this day. First off, this is appreciable. Next paragraph. In the above circumstances, the petition is disposed of, putting OP number 3 to the strict warning that should he fail to dispose of the appeal in question within 1 week from this day, the court may personally summon him personally for taking appropriate action, which may include payment of heavy compensation to the petitioner.
Lordship, a seat may be reserved.
Have you made him party?
OP number 3 has been made. Post collector.
OP number 3
collector
is requested to keep one seat reserved. Not OP number 3. Not a party. The principal of the institution is requested to keep open one seat till disposal of the appealing question. First off, no costs. And the all contentions of the also of the same somewhere put that sentence.
Item 49.
Next.
May I please, Your Lordship?
Yes.
Well, the petitioner is seeking for a direction to the opposite party to appoint him under the Rehabilitation Assistance Rule.
Brother, you should tell OP number 3. Suppose because of this order he passes wrong order with malice, then he will face undesirable consequences. Okay? Yes.
Immediately, Your Lordship. Well, the petitioner is seeking for a direction to the opposite parties to appoint him under the Rehabilitation Assistance Rules 2025, my lord, as his adoptive father died on 8/7/1994, that is before commencement of the OCS Rehabilitation Assistance Rule 2020. My lord,
Earlier, what the other order you have passed now? CB order?
my lord?
DB will come to page 11. That Honorable Acting Chief Justice and
Yes, my lord.
Well, the virus of Rule 6(9) of the 2020 rules were challenged. My lord. Yes, my lord. Then it was declared ultra virus, my lord. And the new rule, my lord, amended rule, that is 2025 rule, came in under Annex 11.
What the impugned order says?
My lord.
Impugned order.
No, my case has not been rejected.
Not yet rejected.
Not yet rejected, my lord.
Only consideration.
Yes, my lord. Lordship, kindly have a glance at Annex 12, page 43.
12.
Yes, my lord, page 43. The DO has sought for clarification from the director whether the adopted son can be appointed under the rehabilitation assistance rule or not, my lord.
Where is your representation?
I have not made a representation, my lord. As this clarification is pending, my lord.
It is pending since how long?
Since 2/6/2025.
That's about not even 2 months.
And there is a judgment of this Honorable High Court, division based judgment, that the adopted son can be appointed, my lord, under the Rehabilitation Assistance Rule 1990.
When were you adopted?
Adopted, my lord.
And at what age?
Yes, my lord. Adopted on 18/1/2006, my lord.
18/1/2006. Deed is?
My lord.
Deed.
Yes, my lord.
Where is that deed?
Deed is under, my lord, Annex 8, page 30.
30.
Yes, my lord.
There is a suit also.
Yes, my lord.
If the held adoption is valid.
Yes, my lord.
You take notice. Yes. Issue emergent notice. Learned standing counsel, additional standing counsel, Shri so accepts notice for the respondent. All respondents?
Yes, ma'am.
All respondents. Call in the 3rd week of August, let's be confirmed. Since a short point is involved.
Can be 50. Yes, my lord. In this case, the Secretary of the Managing Committee, Sorosori Sisumundir, has filed this case where he is seeking for a direction to the opposite parties to grant certificate of registration, COR, as opening permission has already been granted, my lord.
Permission for opening is one thing.
Yes, my lord.
And certificate of registration is another.
Another thing, my lord.
Two separate things.
Yes, my lord. Two separate things, my lord.
Under the Education Act.
Yes, my lord.
Which section?
Let me pass over this matter kindly. I will bring the rules, my lord.
Next week. To come with more preparations.
Let it come tomorrow. Next week.
Item 51.
May I please, Mal? Mal, recently there is a Kendriya Vidyalaya. It is opened at Titlagar in the district of Balangir, in the western part of Odisha, Mal. So there is an advertisement for the admission of the class 1 to class 5, Mal. The present petitioner is a contractual lady teacher, Mal, and she has applied for her daughter for the category 3, Mal. Now the Kendriya Vidyalaya, they are saying that the contractual teachers not coming under the category 3, but category 3 is particularly for the children of the government employees. But my question is that, my lord, if I am a contractual teacher, I am not a lawyer, I am not a doctor, then what I am, my lord? What is my status? And they are denying to take admission of my daughter in category 3, my lord.
How long you have been in contractual service?
Since last 10 years, my lord.
10 years.
Yes, my lord.
My lord, I have received the copy. As per the admission guideline, there is for the admission guideline 2025 and 2026 of the Kendriya Vidyalaya, the clear definition for the state government employees, for regular employees, those who have substantial accepted the substantial posts.
It does not fit into that.
No. Yes. There is another category of the category 5. And the principal in her representation clearly endorsed that she will consider as a category 5. When it will come, and now the admission process is going on, not yet completed. If there will be no post to apply for the category 1, 2, 3 as per the priority category from 1 to 4, then her case may will consider.
It's in order of brief.
If not,
absolutely, that is the priority category as per the admission guideline. There is the policy decision of the government, Kendriya Vidyalaya. And as an autonomous body, as your lordship knows, then she has to wait till the whether he may be, our case may be considered under category 5 because he wrongly applied for the category 3.
No, that's the problem, Malad.
No,
We are
not on the
they
category
are
3.
not admitting the contractual teachers, Malad.
Absolutely, that is the guideline.
Where our-
That is the admission guideline.
But you challenge it.
Not at all.
No, my representation is pending, Malad.
You have not challenged the guideline.
No, I have not changed the guidelines, but my representation is there, Malad. So I have solely to consider my representation, Malad. Because from themselves, they are going to start the admissions, Malad. So Lord, let them have to consider my representation. If they reject, Malad, then again I will come before the Sultan of the Honorable Court, Malad.
Within 3 weeks, SCL should direct to dispose the representation in accordance with the admission guideline. We have no objection. In accordance with the guideline of the 2025 to.
The short grievance of the petitioner is as to the candidature of her daughter not being considered under category 3 of which guidelines?
Kendriya with the admission guideline 2025-26 academic session.
Kendriya Vidyalaya admission guidelines 2025-26
academic sessions.
First, learned counsel for the petitioner passionately argues that the petitioner happens to be a contractual employee in the state service and therefore the candidate would fit into category 3 earmarked for the children of civil servants.
Yes, sir.
First, learned panel counsel appearing for the
Kendriya
Vidyalaya Sanghatan with equal vehemence submits that there are totally 5 categories and that the candidature of petitioner's daughter would fall in category 5 and these categories are organized on priority basis. First, having so contended, he submits that the candidature of petitioner's daughter would be considered under category 5
as endorsed in the representation itself by the principal.
As has been already endorsed in the representation of the petitioner.
By the principal, concerned principal.
Comma, such endorsement being made by the principal himself. Herself. First up. Next. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited indulgence in the matter in as much as there is no challenge to the guidelines in question. Sir. Secondly, there is an assurance from the side of the respondent that case candidature of the petitioner's daughter would be considered in category number 5
as per the guidelines,
as enumerated in the extant guidelines. First one. Next, in the above circumstances, the petition is disposed of with liberty to the petitioner to approach this court in the event the selection does not occur in favor of her daughter. First, in that connection, all contentions are kept out.
Hello, more than certified a copy in the course of the day because from tomorrow.
In
the course of the day.
Tomorrow it will be
Yes, hello.
Parties to act upon the most copy.
I name Rishikesh Tripathi.
Rishikesh
Tripathi. I have given this already slip.
And you have given that.
All right.
Item 52.
This case, my lord, I will be grateful, my lord. 1, 2, 2, 3, 3, 25. Your lordship may take up. 5, 7, 2, 2, that is not pressed.
5,222, you do not press.
Not pressed. No, subsequent bit.
5722 of 2025.
Not pressed.
Along with IA number 12233 of 20.
1, 2, 2, 3, 3 may be taken up.
Why? IA is in which?
Your lordship has
If that goes, IA also goes. If tree goes, French also goes.
No, that is
IA
the,
remains.
no, I 5722. That is the petition I have filed. Actually, the second petition, revised petition I have filed.
Okay. So the only this
Only that is 5722. I will pray.
W. Huh? W. IA number 5722.
5722 only.
IA number 5722 of 2026 is disposed of as not pressed. Okay.
So my lord, I will be grateful. 12233 may be taken up. 12233.
Yeah.
And this is a case, my lord. He is working senior research fellow since
Give that petition.
flag D.
Flag D.
Flag
In the
D.
same petition.
No, petition. Flag D.
Who is your opponent?
Union of India is there, and
You are ready in the matter?
My lord,
they have not filed
we
counter.
have received the parawise, my lord. We need some time to file them.
They have not filed counter.
2 to 3 weeks to file them.
No.
Appearing for the university, my lord, before.
University is appearing.
Not who against whom you are
My grievance is against Union of India. Open number 2.
you file the
We are appearing for the same, we will file the counter.
but within 30 under your rules. Within 30 days, you ought to have filed the statement or the counter.
It rules is there, but sometimes it is not possible.
I cannot be a mogul here. I am a judge where
Lordship has a discussion. Lordship has a discussion to consider our grievance. That part, my Lordship has a scope.
year is over and still you are speaking of grievance. You should have,
The discussion cannot be withdrawn by the court. Court has a power to either accept or reject.
no,
That's what
if you insist, I will reject is one thing, but you are bound to file the objection statement. We know which case to reject, which case not to reject. You cannot advise me.
No, I am not advising, my lord. I am saying that I think my lord may misunderstood me. I am saying that even though time has been given, my lord has a power to accept our prayer.
We have power also. It is regulated under the rules. You have to file the objection statement within 30 days from the date of service of notice. Nobody is filing.
What is happening, my lord, is I am conceding to that one. Yes. I am conceding, my lord, it is not happening. It is not possible also.
2 weeks granted to file the counter if any. Failing which right to file one stands rejected.
My lord, I pray, my lord, they have not released the salary. That is the petition I have filed in the
Objection, let it come back.
not salary, and that has been recommended, and that has been, they have also indicated stay is operating, and I am not getting salary. Since 4, and the budget has been placed since 8/11/24.
We'll call this matter on 20th of August.
Obliged. Obliged. Interim order. Interim order.
Is there
Interim order.
interim order to continue? See, when there are rules, whether Union of India or UNO, they have to follow the rules. Simple. Union of India or state government is not above the other litigants. They are on par with the litigants. Yeah.
1953.
Petition for amendment of the first title of the writ application, my lord. Notice issued, but it is a form unserved on the opening of 4 and 5.
You will take fresh notice.
Only 4 and 5 they will be I will give in that.
Copy of the amended petition is not available.
I will give you.
You give amended petition, one more copy. Correct. Fresh steps in respect of
4 and 5 there will be, I will file a consolidated page number 2, my lord, of the writ application. By inserting the purport of this matter. Therefore, notice will be issued. The notice was already issued, but due to the
because of fresh steps in respect of answered respondents
4 and 5.
4 and 5, OP number 4 and 5, with appropriate addresses.
Only
within 2 weeks.
page number 2 may be consolidated page number 2 will file. I may permit to file.
Consolidated
Page number 2 of the writ application. That is the address.
consolidated page number 2 of the WP is permitted to be filed. Okay.
Copy the
Yeah.
24. May I please, Your Lordship? But I have filed one IA. Virtually, this is a covered matter. Here, my grievance is the petitioner was appointed as a junior assistant under the Rehabilitation Assistance Scheme.
Ready in the matter.
Counter has not been filed, but this can be disposed of
Without counter also.
because this case is covered by the order passed by this Honorable Court.
What is the relief?
That IA number 10718 of 2025. The relief sought for in this case is, well, I was appointed as a junior assistant on 28/1/2020 under the Rehabilitation Assistance Scheme. That is in accordance with 1990 rules. Then, my lord, under the 90 rules, there is no provision for contractual appointment.
No provision.
There is no provision for contractual appointment. Only regular appointment can be made under the Rehabilitation Assistance rules. Under the Rehabilitation Assistance rules. But as a matter of fact, they appointed me on contractual basis on 28/1/2020 under Annexure 3.
Yes, sir.
Thereafter, you will also may kindly turn to Annexure 9 at page 35. While they regularized my services with effect from my date of initial joining, that is 5/2/2020. My lord, may kindly come to page 35, Annexure 9.
Annexure 7.
Annexure 9 at page 35.
35 Annexure 7 is being shown.
It was 7 and 9.
14/3/24.
No, 6/7/23 later. Order 6/7/23 order. Go on, Page Annexure 9, page 39. Sorry.
Yes.
Serial number 4, Abhishek Parida, junior assistant, effective date of regulation 5/2/2020. My lord, got it?
Yes.
Thereafter, your lordship may kindly, my grievance was reduced and Annexure 10 at page 37 may kindly be sent. Page 41. Here, my lord, my pay was fixed
41.
in terms of ORSP rules 2017, serial number 4, in a particular level and scale. Abhishek Parida. Thereafter, my lord, before that order was implemented, another communication was made on 3/7/2024, that is under Annexure 12 at page 46.
Impugned order.
My lord, impugned order.
46.
46, Annexure 12. Your lordship may kindly see towards bottom, third paragraph.
The said circular.
The said circular was later withdrawn by department at letter number such and such 99/2020, and the contractual appointment rules relating to rehabilitation assistance scheme in aided educational institutions were not applicable. So the Odisha Group B, C and Group D posts repeal and special provision rules 2022
will also not be
applicable in case of those employees who are appointed under the rehabilitation assistance scheme, which was given effect within the period from 1/8/2019 to 9/9/2020. Therefore, when the repeal rules 2022 will not be applicable, those employees will be guided by the rules prevalent at the time of their appointment, which speaks of regularization after 6 years with the remuneration as per the corresponding
metrics
along with changes from time to time. My submission before your lordships is, admittedly, my mother, who was a trained graduate teacher in an aided school, she died on 10/1/2014.
10/1/2014.
10/1/2014. I, being her son, I made an application under the OCSRA rules 1990, because so far as OCSRA rules 1990 is concerned.
Can I come afternoon?
Yes.
Then Bob is not there.
Lord, that sore matter can be taken up. Mr. Swami.
Password.
Which one?
What a
Launch for
race matters.
First or matter?
Race matter.
Fresh matter. Yes. Give that.
Item.
1 second.
Item 24.
What is this matter?
My lord, yesterday this matter was there and your lordship directed me search that judgment. That is a dispute relating to principal in charge. I have brought that judgment.
That Basura
Yes.
managing director.
That judgment and your lordship judgment. My lord may kindly.
Justice
Najid judgment. No. And your lordship has also delivered a judgment sitting in division bench referring to that decision. I have brought that.
Correct. They have that judgment with you.
But your lordship judgment in division bench, देखे दोनों sir. It account.
Division bench.
Following that judgment.
Holding that?
Yes.
Yeah, this is the judgment.
Paragraph 13.
1-3.
1-3. No, sorry, paragraph 12. In-charge arrangements and promotion are well understood in civil service. Posting an officer in the lower post to discharge the duties of the higher post without promotion is only an in-charge arrangement. It is the exigencies of public service that will be the relevant consideration and not the consideration of seniority while making such arrangement. A person was posted on independent charge basis does not hold the post and promotion and other things are there. But following this judgment, your lordships also delivered a judgment. My lord may kindly see that judgment will come to my rescue. Paragraph C, page 8, internal page 8. The concept of ad hoc appointment is not alien to service jurisprudence. It is a common knowledge that civil servants are appointed on in-charge or independent charge basis in the post only as a temporary measure under Rule 32 of KCSRs. In such cases, ordinarily the seniority does not much factor. A learned single judge of this court that has been referred to, then your lordship may kindly come to subpara D. Ordinarily, I am relying upon this. Ordinarily, seniority has a pivotal role while making promotions on regular and substantive basis. However, when it comes to making ad hoc appointment as the ones at hands, ordinarily seniority takes the back seat. This is not to say that authority in making ad hoc appointment can choose whomsoever it wants. Even there, the requirement of fairness and reasonableness cannot be dispensed with. I am relying upon this. The proviso to section 30 does not say anything about seniority whilst making appointment as a temporary measure. The appointment process has to be normative. Since it is done in the exercise of statutory power is true, there is some discretion that avails to the appointing authority, even under section 30 of the Act also, cannot be disputed. However, any discretion has to be exercised in accordance with the rules of reason and justice, said Lord Halsbury in such and such case. Then other things are there. Yeah. And here,
your case is
my case
qualification at all.
No, well, he has no qualification at all. And second is, I am senior to him. And my third point, this is the most important point, relying upon this judgment. My lord, this arrangement, although it is a temporary arrangement and principal in charge post is not a substantive post, but so far as state of Odisha is concerned, whoever is in charge of principal or whoever assumes the power of principal in charge, he virtually discharges the duties of regular principal. Everything he will do.
You take
I'll take information because on the retirement of the principal concern, this interim arrangement has been made under Annex 7 is the impugned order.
But he could have chosen him is the point. What he says,
so for this senior,
your discretion is all right. But that discretion is not of a Mughal discretion.
Yes.
That I will give Farman, I will not give Farman, I will withdraw Farman. That is not the kind of discretion in a constitutionally ordained state.
The date of joining and the educational qualification.
Have to be looked into. Otherwise, there shall tomorrow he will make entries in his service record adverse to him. What should happen? There are very many aspects are there. After he argued, I was just thinking, yes, all these judgments went on a particular plane. But suppose if a junior most officer is put in charge of the...
Obviously, it is embarrassing.
Very embarrassing for the other person.
We are conscious, Mila. But so far this interim arrangement is concerned, very particular. Let me take instruction, be it on Monday. I don't say that it is a Katak, Mila. It is a Katak.
There should be somebody.
So I can take the phone also. Monday. I don't pray for more time.
Till then, your lordship may protect.
Monday or Tuesday.
Till then, the order may not be given effect.
That cannot be because
Monday is another matter fix.
The apex court said principal is conscience keeper of the college.
It's
There must
absolutely
be
good.
somebody.
Absolutely good.
Otherwise, it will be headless. Somebody there should be. Then we'll come to one Tuesday. We'll have that.
Tuesday I will come with you.
Tuesday.
But 66 may I pray. Everything has been completed pleading. It is a matter of 24. May I pray for next week, my lord? I will intimate. Yes,
You
I am for the government. I can intimate the other side, my lord.
Well, well. Inform the others.
Yes, sir. Yeah. Deep level.
Next. That's 54. Yes, ma'am.
Yes. My grievance is that after the death of my mother, who was serving as a trained graduate teacher in an aided school, my mother died on 10/1/2014.
10/1/2014.
By then, my lord, so far as OCS RA rules 1990 is concerned, which is meant for government employees, that benefit was extended to the employees of aided educational institution.
You had applied for compassionate appointment on which date?
My lord, that yes. I have not given the date.
Okay. When order was issued?
Well, the order was issued on 28/1/2020 under Annexure 3, appointing me on contractual basis against the post of junior assistant.
Dated?
Dated 28/1/2020 by the order of the District Education Officer, Khurda. But while continuing on...
This is for admission?
No, this is for orders. This is for orders.
Orders.
Orders because I have annexed a copy of the judgment which covers my case. That is in my...
Who appears for the respondents? Covered by the judgment.
Give me a copy of the judgment. I have already served a copy.
Because the government...
All right, I will give extra copy.
Keep on changing.
Yes.
Therefore, give one more copy.
Yes,
We'll
yes.
have it off.
Yes, yes, I will give.
This matter on 22nd of 21st of August will be specified. If it is covered,
My lords, your lordship may direct to consider that. Similar matters.
to consider will be sufficient.
Yes,
Huh?
yes,
With that order, you will be happy.
yes, yes, yes.
Consideration of which representation?
Representation is not there. Your lordship may was the impugned order.
That is Annexure 7.
Then that clashing becomes a bit difficult.
And then let it come on that day. But may I suggest one thing? I will make a fresh representation.
Yes.
I will make a fresh representation to the government and let the government consider my case in the light of that judgment.
What is your grievance actually?
My grievance is that initially I was appointed on contractual basis.
What you want at the hands of the government?
I want that my service has already been regularized from the date of my initial engagement. Now another order has been issued.
28/1/2020.
Yes. Another order has been issued. No, so far as regulation is concerned, you will also may kindly see that order I have annexed. That is at.
What I suggest is give this copy of the judgment to him.
Yes.
In the event we can grant the relief.
Yes.
Also.
Then positive order can be passed.
In rehabilitation assistant matter, my lord, the Honorable Apex Court has.
No, it's a different matter. He has been appointed and he has been given regular
So
status.
another judgment here.
He has been given regular status, not that he's.
Then you argue the matter. Have you filed the objections?
We have not filed.
No.
Then it is short objection you should file this time.
One file.
I do not know why your lawyers do not, government lawyers do not file objections at all. But short objection should be always filed. It should be on record. Suppose in the event it goes to Apex Court, then you will take up the contention. We are not given opportunity of hearing. Therefore, file your objections. He will know what is your stand. That becomes easy.
Well, let it come along with WPC number. There are two similar matters, 28659 of 2024 and.
Slowly. Yes, to
Yes.
take that. Check. All along. 120.
Item 14, pass over item 14.
1/4.
1/4.
Why lawyer has not well or what?
Hey, please. Item 14. The recovery commuter hello pension.
Recovery from pension.
Recovery from
What is your
12 years have been passed. He was retired in the year 2012.
2012.
And the commuter value was sanctioned in the year 2013. And yes, already
Excess pension is paid to you.
excess pension I applied, that was sanctioned.
What were you earlier?
My lord,
What was your designation?
a teacher, high school teacher.
We have stayed recovery in similar matter.
Similar or others, coordinate bench also stayed.
Give that. Issue emergent notice.
Senior was there, Mr. Lanka was also there.
Is requested to accept notice for the respondents. First, learned counsel for the petitioner draws attention of the court to a coordinate bench interim order dated 8/7/2025 interdicting recovery from the pension, and therefore petitioner too needs to be granted similarly. First, I agree. Next one, in view of the above, issue stay of recovery from the pension till next day. On this matter, along with WPA 18052.
My lord, notice should go to opposite party number 2 because we don't appear for controller of accounts.
OP number 2. You appear only for one.
1, 3, 4, 5.
1, 3, 4, 5. Well, that was emergent notice.
Notice my lord within a week. Notice within a week. OP2.
OP2.
I will take notice.
Yeah, you take notice. Interim order shall not be released till steps are taken for effecting notice to the OP number 2. If you pay a process, they will release the otherwise not. Yes.
Item 41.
Yes.
May I please, my lord?
Yes.
Well, the petitioner is challenging the illegal.
Okay.
May I please, man?
The petitioner is challenging the illegal suspension imposed as a punishment on the petitioner, Your Lordship.
Illegal suspension.
My Lord.
Suspension is by of punishment.
My Lord.
For what misconduct?
No misconduct. Your Lordship may kindly. Fact is, the principal of the college was surreptitiously deducting some amount from my salary from many years. I stood up and I took information. I sought information. It was found that he has made a ghost loan in my name and he's recovering that in phases. So when I complained about that, in an act of total vendetta, 2 days before his own retirement, he has suspended me without any.
When it happened?
26th, Your Lordship. 26th April. My Lord, the rule provides that he should take the approval of the director of the department. No approval has been taken. Nothing has been done.
26th of
April, Your Lordship.
But where were you all these days?
My Lord, because I had to wait, because if it gets the approval of the government, that's what is the time. There is 2 months time for if any suspension takes place, it needs to be approved by the government. But no approval has come. So that's why I had to wait for the government to, whether they are approving or not. They have not approved. So according to rule, this suspension should go.
Yes, sir. If there is no approval by the government, then how suspension will be effective under the rule?
None.
Issue emergent notice. ASC is requested accepts notice on request of the court.
May I prevail upon?
And notice will go to only opposite party number 1, my lord.
You appear for 2.
No. I appear for 1 only.
1 only.
Yes.
Then how many others are there?
2, 3, 4 are college.
Issue emergent notice to others.
My Lord, only small prayer. This principal, totally out of rule, has fixed my headquarters 70 kilometers away. I am a polio patient and I am also suffering from various ailments. As an interim, if I am allowed to report in my own college, because 70 kilometers traveling and no subsistence allowance is also being given.
Petitioner, though would continue under suspension, is permitted to report at
his own college.
At his own college.
B.S. Subudhi College, Daspala.
Which is respondent. Which respondent?
Respondent.
At his own college. This extraordinary interim arrangement is made because of pleaded polio disease, which petitioner is stated to have been suffering from.
Yes, please, Your Lordship. I have filed a better consolidated cause title in this as per the writ petition. There are 5 opposite parties. So 4 register Barampur University, Bhanja Vihar. I shall implead this party. Thereafter I shall hear this.
You have impleaded now?
No, I have impleaded 4 opposite parties.
You have filed application?
Yes, ma'am.
Where is that application?
In this writ petition 4319, there are 5 opposite parties.
You have sought for impleadment?
Yes, ma'am. Yes, ma'am.
Where is that application? Where is impleading application, brother?
Consolidated cause title, page 1. Party implead कोटे है ही परनी सर से. Consolidated
2 and 3 you want to delete?
Yes, ma'am.
Response 2 and 3 you want to delete?
Yes, madam.
And in their place, whom you want to implead?
So, opposite party number 4, register Barampur University, Bhanja Vihar.
Yeah. I think it is there. Registered already in
Opposite party 4. Only 2 and 3 you want to delete. That's all.
Yes, ma'am.
Opposite number 4, OP number 4 is register only.
Opposite party number 4, register, ma'am.
Correct. Whom you want to implead now?
Now 4, opposite party number 4, register.
He is there already.
Yes.
You want to delete 2 and 3.
Better, I may be permitted to withdraw.
You want to withdraw the petition?
No, entire petition. Not in the entire petition, just the consolidated cause title. Permitted to withdraw and file a better consolidated cause title.
How can that be done? You sought for deletion, I can understand. Where is another application for impleadment of other persons? This application will allow. हिंदी बोलने आता है, हिंदी में argue in Hindi. I'll understand. Assisting, rather assisting what he wants to. Yes. The petitioner has filed an application in IA number 6897 of 2025 seeking leave of the board to amend the petition as sought for therein. First off, there are 5 of the
IA number 4708.
There is a schedule which he wants to introduce to the cost table. First, another application in IA number
4708 by 2025.
4708. 4319 is there.
4708. Paragraph 2. Page 2. Already I have mentioned.
First one. That other application is moved in IA number 4708 of 2025, seeking deletion of OP numbers 2 and 3 from the case title. First off, both the applications are supported by an affidavit. First off, admission has not happened now.
No,
it's for admission.
Yes,
matter is for preliminary, but for a first time it has come.
For orders, ma'am.
After notice.
No, notice has
been issued. But respondents are yet to be notified. First off, these applications are moved at the earliest point of time. Right. First off, if these applications are allowed, no prejudice should be caused to anyone. First off, if not allowed, prejudice may be caused to the petitioner, as argued by learned counsel for the petitioner rightly. First, in the above circumstances, both the applications are allowed. Semicolon. OP numbers 2 and 3 are permitted to be deleted from the array of parties, and new parties are to be loaded in their stead. First off, consolidated the cost title to be
that may be fixed, my lord.
Which date you want? Within 1 week. You will that consolidated.
11th August.
Call this matter on some of the 11 date. So why it is very auspicious day for you? 11/8.
No, man, any other date may be fixed, your lordships, because
you have asked that date, we have given that.
Please, your lordship. And this application relating to grant issuance of transfer certificate in favor of the minor daughter by the principal Kendra Vidyalaya. And my lord,
what happened?
in the Kendra Vidyalaya.
Yeah.
That is dispute between husband and wife.
and divorce petition filed. The father of the child filed an application before the concerned principal not to issue TC. And in this regard, on that application, I have filed counter before the coordinate bench. After seeing that allegation, the court has directed to the applicant counsel to file objection to the counter. In the meantime, husband already agreed to
Already given consent.
given consent to.
Petition has become infructuous.
No, my lord.
He has given, unless your lordship direct on the basis of his letter, your lordship has to direct to issue TC to the mother.
Your lordship
cannot give, because allegation, without application, that is that.
Now the husband
Without leave of your lordship, we cannot give. Your lordship on the basis of.
The short grievance of the petitioner relates to non-issuance of transfer certificate
To the mother of the
to
child.
the in respect of petitioner's daughter.
petitioner's daughter. Petitioner daughter.
Legal guardian, husband and all.
Petitioner daughter
Miss Divyasri Sethi.
is Divyasri Sethi, into brackets, standard 6, CD 6. First up, learned counsel,
For the
panel
Kendriya
counsel
Vidyalaya
appearing for the
Kendriya Vidyalaya Sangathan.
Vidyalaya Sanghatan submits that now that even the husband of the
Husband of
father of the child
mother of the child, given the alleged they're not to
who is that? Who gave that?
Now the child in custody of the her mom with her mother.
give the TC to the mother without his consent. Now he came back to the you handed out. Handed letter kindly agreed. That letter issued by the husband.
panel
Consent letter given by the husband.
By the father.
learned panel counsel appearing for Kendriya Sangatana has placed on record a letter dated 16/7/2025 allegedly issued by father of the child.
Given the
signifying consent for the issuance of transfer certificate
to the mother.
in favor of the mother. In favor of the mother. First up, he further submits that if this court, in the light of this letter, issues a direction
To the principal.
the principal,
OP3 man.
OP number 3, will have no difficulty to issue the certificate.
OP number 2.
OP number 2 or 3?
2 my lord principal.
OP number 2.
Original principal.
Principal, you can see. Principal. What you have written? No difficulty in issuing the certificate in favor of the mother. First up. Next paragraph. In the above circumstances, petition is disposed of, directing the principal of the college school in question to issue transfer certificate to the petitioner mother within how many days?
Within 7 days, my lord.
Within 7 days.
Along with the order, you will have the
Within
immediate.
7 days. First up. Web copy to be acted upon.
My name.
Write his name also. In big letter, you can write his name. All right.
Item 57.
My lord. In respect of my lord, OP number 1, 2, 3, I have served copy. The extra copy of writ application to Mr. Amitabh Tripathi on behalf of the corporation. I have also filed the receipt. That is also my lord official note. My lord, I may pray that the issuing notice to OP number may kindly withdraw that receipt as it may kindly be accepted.
I have not understood even one sentence.
My lord. In respect of OP number 1, 2, 3 corporation, I have served the 3 extra copy to the corporation advocate, Mr. Amitabh Tripathi. He has given the receipt. I have also filed the receipt. That is also my lord official noting. But the order that the requisite to be filed may kindly be dropped, that receipt may kindly be accepted.
Learned counsel for the petitioner submits that since copies of the petition along with all the documents have been served on the panel counsel appearing for
OSRTC,
opposite party number
1, 2, 3.
1 to 3, the furnishing, the requirement of furnishing what? Requisites is be dispensed with. First, I agree. Yes.
This case may come next week along with the present.
Yes, call this matter. Week after next, we'll have that.
Next
Week after next.
along with this.
Along with WP number 12. Okay.
Item 59.
Items.
58.
58. Why you are angry with my friend or what? Yes. He's thinking of many cases like this every day.
Petitioner challenging the rejection order dated 21st January 2025 for rejecting my prayer, my lord, for releasing of the current salary, though he is continuing since.
Take notice.
My lord.
Issue emergent notice, learned ASG or ASC?
Israel.
AGA. On request accepts notice for all respondents.
Yeah, all respond.
All respondents.
There is a delay, my lord.
Delay.
Delay 72 delay. Delay may be condemned, my lord, 72.
Your lordship's disclose.
An application is moved seeking condonation of delay.
72 days.
Delay being short, that is 27 days.
72.
72 days. And there being a plausible explanation, request for condonation is acceded to and delay is condoned.
Item 59.
May I please, my lord? This is a petition where the petitioner is seeking coverage of the judgment of this Hon'Ble Court.
Covered by judgment. What is the prayer?
Prayer is to grant in aid.
Grant in aid.
My lord.
Already similar matters are treated by recorded benches.
My lord.
You take notice.
The judgment is.
Did you make the representation?
335 days delay.
335 days delay.
My lord.
Let him file objection if he wants.
The question is because the lower tribunal had rejected my case on a particular pretext, my lord. That has been adjudged by this Hon'Ble Court that we are eligible. So the common judgment has been passed in.
All right, but delay has to be confirmed. We'll issue notice.
Yes, on delay.
Issue notice. Learned AGA requested to accept notice for which respondent?
Respondent number 1. Basically to be done by respondent number 1.
No. 1, 2, 3. All respondents.
Except 3.
3 also.
Except 3.
You're right. Learned AGA on request accepts notice for respondent numbers 1 and 2. First off, issue emergent notice to OP number 3. Returnable within 3 weeks. First off.
Item 61.
On merits and on limitation and on merits. Yes, sir.
61.
May I please, my lord?
Yes, sir.
In this case, my lord, I seek your lordship's kind permission to present this case on behalf of Mr. G.K. Bharti and Associates, my lord. My name, in fact, is not there on the Vakalatnama, so I may be kindly.
What is this case about? In more sentences. Then we'll go to the paper.
This relates to granting a plot, my lord, developed by Bhubaneswar Development Authority, BDA Authority, where e-auction was held and the petitioner was admittedly highest bidder. L1. My lord, for convenience, my lord, I would.
They granted plot or they did not?
They refused to grant me.
They refused to.
Citing the reason that in earlier e-auction I participated, and in earlier e-auction, though I stood L2, because L1 chose not to take the plot, I became L1. And because I became L1 in earlier bid, in second bid, even though I am L1,
we cannot be.
I do not qualify to demand.
Which is that rule?
Well, that is their brochure. I'll take your lordship to
that brochure. I have handled many such matters.
My lord,
I will take your lordship straight to impugned order, Annex 6. That is more.
Go to brochure. Your case is brochure.
My lord, they say may I just play your lordship. Annex 6, page 20 of the writ petition.
Page 20. So, you have not deposited the amount.
You have been considered as selected bidder in respect of plot number K 4 by 1306 in the e-auction held on 10/3/21. Further, you have been intimated by letter that so and so to deposit the balance EMD amounting to 2,27,000. Next para, you have not deposited. Thereafter, my lord, it may be mentioned here that since you have already been accepted in a selected bidder earlier, slightly wrong, your candidature have been cancelled in respect of e-auction held on 25/3/21 by the empowered committee on allotment. However, you are eligible for refund of the initial EMD of 5 lakh deposited for e-auction held on 25/3/21. This made me aggrieved, my lord, for which I am before your lordship.
Last line.
Taking note of the confusion arisen, it is once again reiterated that you have been accepted as the selected bidder in respect of plot number so and so 1306, my lord, for which an amount of 2,27,200 is due to you, due on you. As an exception, you are once again given a chance to deposit the amount due to you for plot number 1306 within 7 days for issue of this letter. Thereafter, my lord, I will just request my lord to kindly take note of 2 plots. Confusion is between 2 plots. If my lord will take note of 1 plot, that is K 4 by 1306, measuring an area of 12.
1 second.
K 4 by 1306.
This is one plot.
1 plot measuring area.
Leave it. Number is there, na? Another plot is K.
Another plot is plot K 5 by 477.
There are 2 plots.
2 plots.
In the same layout?
If your lordship will also
clarify. Are these plots in the same layout?
No.
Different layout.
Different layout.
One is in which layout? K4
1306 are slightly smaller plots, my lord, measuring area 1250 square feet. That is why I was praying your lordship to take note of the measurement.
1250 SFT.
My lord. And the other one, my lord, measuring 2037 square feet.
Almost double. Less than 2073.
2037 square feet.
37.
Now, as I stated your lordship, my lord,
auction, both the plots were put to auction.
In 2 different spells,
correct.
In
first was put on auction on 23/3/21.
E-auction was held on 10/3/21. 10/3/21.
Just notes, fine.
Well,
petitioner was the bidder in e-auction held on 10/3/2021 in respect of plot number K-4/1306 at measuring 1250 SFT. First off, he had remitted the EMD amount of rupees. No, he had not remitted any EMD.
No, he has deposited
EMD amount of rupees.
He has deposited 5 lakhs towards.
No, that is the second plot.
Fixed EMD. 5 lakhs. 5 lakhs. 5 lakhs. 5 lakhs.
5 lakhs.
5 lakhs.
5 lakhs. First, the auction in question, he happened to be L2, And L1 having
H1, H2.
H1, H2. Ah, you are right. It should be highest. H1, comma, H2, comma, H2, semicolon. H1 having not come forward to accept the offer, comma. H2 petitioner is treated as H1 and he was issued a notice dated 23/3/2021 to come forward with the balance of the money.
Balance
Rupees 2,27,200.
Balance EMD.
Balance EMD in a sum of rupees 2,77,027. 2,27,200 in 10 days. First off, this is one set of facts. You did not do that. I am asking the fact.
Correct.
Petitioner did not positively respond to this notice. All right. Then next.
Can I proceed thereafter, ma'am?
No, we'll take a second plot now.
I'll proceed thereafter since my lord observed that I did not comply this. This letter was not in my knowledge, my lord, till I participated in the subsequent bidding e-auction, which occurred, my lord, on
that did not reach you at all.
It never reached me. It reached
How
me.
it was sent, sir? How this letter was sent?
Through mail, my lords, through mail, through the email address they have given. Through mail this is sent, and then through hard copy also it is sent.
Mail also sent. Can you have some proof about that?
Mail number, my lords, that mail number there.
Give it to your friend.
Mail number is there, my lord.
Email address is there.
No, case is not there, my lord. Case is somewhere, my lord.
Let me finish, my lord. It will be convenient for all.
Counsel for the petitioner submits that this letter had never reached him.
Did not reach him within the time.
Within the time, but reached afterwards.
Afterwards, on 26, I have
They reached him, but it was after the expiry of 10 days.
10 days. No.
Because 10 days is prescribed in that letter.
No, not after. After 10 days, not after.
Otherwise, your sentence will not have any sense.
My lord, can I just utter, my lord, two sentences so that my lord can...
Yes.
In fact, the second e-auction was held... In fact, the second e-auction was held, my lord, on 25/1/21.
The second auction was held on 25 January 2021. Second auction. How it can be earlier to 10/3/21 is that can be the first auction then. This becomes the second auction.
Sorry, 25/3. I wrongly mentioned. I'm sorry.
The second auction was held on 25/3/2021.
Where the petitioner?
Where in respect of hearing number K-5/477 head measuring or 2,037 square feet, wherein the petitioner happened to be H1.
Now, my humble contention is also this annexure 4, which according to them was sent on 23/3/21. I received it much later than 25/3/21, and there was no provision. There is no provision for any prospective bidder, my lord, whoever intends to participate in the second bid. If he participate in the earlier bid, he cannot participate in the second.
No prohibition.
There was no prohibition. My lord, ma'am, take note of this.
Counsel submits that there is no restriction, normative restriction on the participation for the participation of the same candidate in successive bids. Yes.
Now, my lord, obviously, I was having interest, my lord, for this larger plot where I was the highest bidder. I will, without wasting time, my lord, I take your lordship to page 3 of the counter affidavit, paragraph 4, filed by the bidding.
Is 3 paragraph 4.
Can I start? That in reply to amendments made in paragraph 6 to 8 of the rate petition, it is humbly stated that in response to first action, one Srimati Subhasini Swai quoted highest bid in respect of plot number so and the petitioner quoted second highest bid of rupees so and stood second highest in bid in respect of the self-same plot. The first highest bidder became also first highest bidder in respect of plot number K426, which means she also participated in both the e-auctions, my lord. For the smaller one, for the larger one as well. And she emerged highest bidder
In the first one.
in the first one as well as in the
Second one.
second one also. For the K426, this is bidder in respect of plot number K4 by 426. My lord, got that?
5, 4 to 6. That is not the plot at all.
No, that is not 477.
Huh?
I repeat, my lord, I first let me come.
1 second.
No, I am not disturbing. I'm not disturbing. You continue with it.
No, if you stand, he gets disturbed.
Oh, then that's so that's it, I can see.
Because, yes.
My lord, initially I prayed my lord to take note of 2 plots.
You said K13046
6 and
470.
777. In their counter affidavit, they say about this
426.
426.
This is not one of the plots in the auction at all.
Absolutely. In the second phase auction. So my lord may also take note of this K4 by 426. This one single sentence clarifies the position. There is no prohibition for any bidder
To participate
in bids, in both the bids. I'll proceed thereafter, madam. As per the brochure that...
One second.
Madam.
When will you send that letter? That
They
letter,
claim-
within 10 days you should make the payment. Na?
They claim, my lord, they sent it on on 23/3/21.
10/3 auction took place.
10/3 auction took place.
On 23/3 they sent the letter.
They sent this letter.
And on 25/3 another auction took.
Second e-auction was held.
So what you say is I had no knowledge of the letter at all is your contention.
Till I participated and
The second
e-auction. And with that also I emphasize further, my lord, there is no express prohibition
for that.
for any individual to participate in both the
In
auctions.
any number of auctions.
In both the auctions. 2 auctions are relating to this case.
Is it your case that even email which they had sent, email address you had given?
They say that email, my lord, this part I never examined because I never thought that this email was never discussed. I have stated in my writ petition clearly, my lord,
Auction itself is e-auction.
e-auction, but I, in my writ petition, I have not stated about non-receipt of mail. If I will further check up, my lord. Right.
May I point it
Again.
out? May I kindly have a glance to page 18.
1/8
of the writ petition. After receipt of the letter, dated 23/3/2021,
He has sent letter also.
well, so he has given the letter.
So he can't say that he had not received the letter.
26, no, I have received.
Well, sir,
From the very beginning, I am telling you also that I have received it.
well, sir, I'm pointing out, well, sir, when he received.
What was
Paragraph 2, my lord.
it is dated 26/3. The next day he has sent that reply. No,
No, no.
23/3 you sent the letter.
20, well, sir, we sent it once 23/3.
Correct. On
He said that
23/3
he said he has categorically stated that on 25/3/2021 he received it. In that paragraph itself. But just one day before, this e-auction dated 25/3/2021. I received your letter such and such dated 23/3/2021 to deposit balance EMD amount of such and such.
That is on 24 he received the letter.
He received the letter. Before the e-auction in respect of the second mailers tender is concerned, second advertisement is concerned, he received it.
No, he received, it's true. But the very next day another auction was taking place. He thought this is a larger size.
So let my learned friend not talk.
This is what he is saying. But his contention that I have not received is not true.
I never said, Your Lordship, that I have never received, my Lord.
No, you received belatedly.
Belated. And that letter also does not reveal there is any prohibition that I am disqualified to participate in the next e-auction, my Lord. So I became...
Now, where is the condition which says, in the event the highest bidder H1 does not come forward within a particular period, the H2 becomes
H1.
The high H1 becomes H1. Where is that condition?
Because that condition may I place it.
And it operates.
That is there in the brochure. The brochure specified it.
One thing, one small broad line I'm putting to both of you. Your object of holding auction is to give the plots to the highest bidder. Therefore, you should have very high justification for not giving the plot.
You're right, man.
He is not a fraudulent man. He is in the open market. He wants a bigger plot. He says, as between small and big, it is man's nature to go for bigger things. Therefore, I want to have the bigger plot. What is the problem with you?
I'm coming, Maharaj. The technical problem is, let's kind of glass to page 15.
No, he sat down now.
I don't want to irritate.
No. Not question of irritating. He has a right to my lord's present it. Because he will permit me and my lord will...
He sensed what is lurking in the mind of the court.
Yes.
Therefore, he does not want to pollute it by further argument.
That's correct, Maharaj. That is also one knack of argument.
It's baseline. Because the chitty on contract treats even tender contracts also. What he says is, if the baseline is to award the contract or award the plots, then this is not done, that is not done, which is not very significant. Should not be a ground for refusing to grant the plot.
Question is that, I think Mayor's will appreciate. Here in this case, brochure binds minors, brochure condition binds both the parties.
Yeah.
Kindly have gloss to page 15, but with due leave minors and my learned friend may, if my lord's friend will permit me, then I will know.
Who am I to permit this?
Otherwise, I am intervening in that.
You can.
Kindly have a gloss to page 15 of my brochure. I have given that brochure or the page internal page 9, annexure A by 2.
Annexure A by 2.
Minutes. Counter.
In your
Counter.
Which provision in the
for pilot's consideration, 6 plus 6.8, page 15.
Page number
15, internal.
Internal 15.
Which counter?
May not. May not be.
That was also counter the change. Why is it the counter change?
Because that brochure is at page number?
Page number starts from page number 9.
Page number 9?
Page number 9. Page number 9 is total.
My Lord, I feel it appropriate to intervene because the counter copy my learned senior friend is pressing now is not actually the copy served to me.
28/2/2022.
I am putting this counter affidavit served by BDA and I related to your lordship by referring to paragraph 4.
This you don't have.
This is bereft of
paragraph 4 is there.
annexures.
Paragraph 4 is there. Paragraph 4 is there. Yes.
Definitely, annex to that, more kitchen, go to the clear.
But it's a code right annexary. A by 2 and B by 2 the mentioned. If you have not got, you could have told it to me. And now 3-4 times it now.
No, please proceed.
No, you can look into it.
Let him.
Next week,
Let
when
him.
is the urgency? So you can look into that and come back with preparation. That helps.
Once my learned
Because
friend
he
says,
should not be taken by
by itself, my lord, child ensure.
what he says. Sometimes we don't affix the annexures. That might have happened, or it might have been misplaced.
Maybe my lord,
Let him have the copy of that.
so I said that is there.
You just look into copy of that.
I'm giving another copy, my lord, so it annexes.
You give another copy. I'll call this matter next week.
Yes. This is authorized ready.
Which date you want?
Kindly accommodate me from 7th to 13th.
You are not
I will be out of station, my lord. Kindly.
out of station, out of country.
Out of station.
All right. We'll have this matter on 19th.
19th.
All right.
19th.
Okay.
Oh, bless.
In this case, my lord, I am appealing for the occupier. I have already deposited. I have the case plot number 5-477 allotted in my favor. I have already deposited 80 lakhs 3,000.
Also,
Because of the benefits of the application, I am not getting position because they have protected.
So you are implicated between
No,
these
already.
two.
He intervened, my lord.
I have it because my.
I would have completed my submission, my lord. He is the favored one.
Oh.
This is a glaring case where how the favored one has been.
no, question is not that.
Whether these two plots are even now available.
But these two plots, because minors have passed a direction not to grant that, not to give possession of that plot, that is now it is our decision of the Hon'Ble Court. It's ours.
Can't it be settled between you people? This suppose instead of, because courts are very slippery nowadays. Which side we will stick,
Because we
nobody
have
can
only-
say. Even Palkiwala
I
cannot
visualize
take
it.
us.
All the money has been deposited by
Sorry,
taking
for that
loan from
something-
different banks.
Something, some interest, etc., it can be compensated. I'm just asking you. See, what kind of order court is going to pass? Who will know? Even God will not know. So slippery we are. Share market, court, and such other things. Somebody said like that. Instead of that, why can't you sit under the shadow of a nearby tree and work out amicably some solution? Brother, why can't you sit
My lord,
for some
I
amicable
would sense my lord's.
He got one plot.
That is smaller plot. Now smaller plot is also kept intact.
Obviously, my lord, this
You are not actually
that part, my lord, whether you, after you get,
Because of the interim order, I have started my.
we started, but we have
Yes.
prevented you from getting that possession certificate,
Yes.
etc. Now that money which you have deposited, that money can be adjusted to the other plot, small plot, because he has applied, and there is some case which appears that way. Suppose if I hold some that you have been favored, then you will not get that plot also. Instead, you can sit. Amicable settlement is the best way in life, in everything. That's the nation. That's the reason. Even the nations which fight in war, they sit amicably to work out some settlement. Can't you make that effort? Ask your client.
Yes.
Because once a case is that the authority has favored you, then you will not get that plot also. Because one who has played these things will not be favored by the writ court. I'm not saying that you have done this, that, etc. Legal position, I feel. If some favoritism has happened,
if my lords will come to a conclusion that is some favoritism, so obviously the case may go that side or that.
Hearing you, only after hearing both of you. But instead of pushing the court to that consideration, you can sit across the table, private in nature, some adjustments with one another. You will get other. You may get
The possibility of exchanging between the two, I think would suffice the purpose of subject.
That's what I am telling. Instead of this one, and you has to be compensated also.
Has to be.
What else is required?
Then I have to take instruction.
Take instruction. Call this matter on 20th of August 2025. Parties are requested to explore the possibility of amicable settlement. Instead of inviting a binding order at the hands of this court. In the meanwhile, first of all. Okay.
Item 62.
May I please, Your Lordship?
Yes, sister.
Your Lordship, in this case, the petitioner is a childcare institution that has been functioning since 1981 in Koraput. And they mostly take care of children who are, it's a tribal dominated area. And presently there are 15 children residing in the childcare institution. The grievance of the petitioner in this matter is, Your Lordship, that the grant in aid that the petitioner had been receiving since 1982 till 2017 to 18 continuously was denied to the petitioner and withheld all of a sudden without any proper reasons given to the petitioner.
Proper reason or without any reason?
Without any reasons, Your Lordship. Without any reasons. And the petitioner has also challenged the same before this Honorable Court. And in WPC number 6925 of 2020, and if Your Lordship sees Annexure 2, this Honorable Court was Annexure 2 of the writ petitioner, which is writ petition, which is on page 26.
What happened in that order?
Yes, Your Lordship.
Go to 29.
Your Lordship, paragraph 4 of that order, this Honorable Court disposed of the writ petition with a direction to the opposite party number 1 to take a decision on the recommendation made by the opposite party number 5 with respect to release of the grant in aid in favor of the petitioner.
That too for the year 2018-19 alone.
2021.
2 years.
Yes, Your Lordship.
And for the year 2021 within a period of 2018-19 to 2021.
Yes, Your Lordship.
That is 3 years.
Yes, Your Lordship.
Within a period of 1 month. What happened to that?
In Annexure 1, Your Lordship,
So in respect of earlier period, it goes.
No, Your Lordship. Earlier period, from 2018 to 19 onwards, they stopped receiving the GIA. And the same was challenged. The petitioner stopped receiving the GIA from 2018 to 19 onwards. And the same was challenged by the petitioner before this Honorable Court.
Therefore, this order is made.
Yes, Your Lordship.
It is like an order to make an order.
Yes, Your Lordship.
On the recommendation.
And thereafter, Your Lordship, the opposite party number 1 passed the order which is there in Annexure 1, which is the impugned order.
In this case.
Yes, Your Lordship.
What is the reason they have given for not giving the grant to you?
The reason given is the last line of page 23, that the proposal has not been approved by the Project Appraisal Board of opposite party number 7. And in view of the same, grant in aid was denied to the present petitioner.
Where is the legal requirement for approval of the concerned party?
Your Lordship, the requirements have been also submitted by the opposite party number 1 in its counter affidavit, where they have stated that the requirements include that it must be registered in the Niti Aayog website, and
those are the conditions.
Yes, Your Lordships. Numerous
Not
conditions.
comply with those conditions.
It has been complied with, Your Lordship.
Still they have given.
Still they have not given.
Why?
Your Lordship, because they have stated that it was denied by the they have stated that they have recommended the name of the petitioner CCI, but the same was denied by the opposite party number 7, the Project Appraisal Board of opposite party number 7. Whereas, Your Lordship, in its counter, opposite party number 7 has stated that opposite party number 1 has never recommended the name of the petitioner CCI.
Not recommended at all.
Not recommended at all, Your Lordship. And in fact, Your Lordship, if Your Lordship sees...
Where was the requirement of recommendation? Which instrument says the particular authority should recommend...
Your Lordship, the opposite party number 1 itself has claimed that it has recommended the name of the petitioner CCI.
And the other authority says we have not.
We have not received the recommendation.
Where is this recommendation which you are speaking? You appear for the response.
I am appearing on behalf of the number 7.
Did you recommend?
No.
In fact, this is borne by the central government. 60%
and 30% by the, it is a scheme.
60-30. Another
30 and 10 by the NGO.
Oh, it is PPP.
Well,
A participation program it is.
this is a scheme.
Under
the juvenile
center
justice.
provides 60, state provides 30,
Well,
and 10 is self-generated.
well.
Correct.
The counter filed by the opposite party number 7 was not given to me.
That was
New one.
and they have also not solved.
But then you can take that also from. You can have exchange.
My lord.
Yes.
If I may interrupt your lordship, the scheme that is being mentioned by my
They
learned
have not received the counter at all. How can they argue? Unless they know each other's stand. You will not be benefited unless they of course you have to argue on your own. It's one thing. But let them settle the dispute first with them. Because you say they have not recommended at all.
Yes, your lordship.
First respondent says they had recommended.
Yes, your lordship.
So if that is solved, then case is decided.
Your lordship.
Is it?
Yes, your lordship.
You give copy to your objection.
My lord.
You serve to.
We'll exchange.
We'll call this matter when? This 23 matter. We'll call this matter on 20th.
20th, your lordship.
All right.
Yes, your lordship. Your lordship, just if one more thing could be just.
That day you will not argue anything.
I will, your
It's
lordship.
something for argument.
Your lordship, this is regarding compliance of the order of this honorable court.
Which?
Your lordship, the order dated 16th January 2025, wherein it was stated that certain letters were to be submitted before this honorable court by the opposite party number 1. Thereafter, it was reiterated on 9th of April 2025.
You have to
We'll do that, man.
Perfect.
By next day, we'll try.
Third learned counsel. Miss Srimati what?
Ankita Mukherjee.
Miss Ankita Mukherjee, who made a passionate submission with clarity. First of all, she drew attention of the court to the coordinate bench order dated 16/1/2025 and complained that even this order has not been complied with by the first respondent.
Yes, your lordship.
First of all. Next paragraph. Learned AGA appearing for the first respondent submits that he would confer with his officials and come back with instructions. First one, AGA to supply copy of his counter to the counsel representing the 7th respondent and learned panel counsel representing the 7th respondent to share his counter with the AGA. First one, for this matter on 20th August.
Grateful, your lordship.
Item 63.
Yes.
I am appearing for opposite party number 4, my lord. I am filing my appearance along with affidavit. I have already served the POP.
You file it in the court, in the registry, because we do not know what are the compliances and other ones.
If the lordship direct, I will file in the registry.
Counsel appearing for the answering respondent seeks a short accommodation to file the counter and the appearance.
I have already served the copy of this petitioner, so also on the state comes.
On this matter on 21st August.
Also, on behalf of Mr. SP Panda, before you appeal for the opposite party number 4, we kindly deleted the name of my state.
Deletion. Name of
Mr.
Sugovikas Panda. Government order.
it is to be deleted.
He has been employed in the state panel.
Sent from us.
So you appear in his place.
Miller.
Name of learned counsel, earlier counsel Shri Panda to be deleted. Okay.
Item 64.
64 not.
Yes, sir.
But here the order of the year, my lords. I is 1 week time for filing the complaint, sir.
You 1 week time I will give you. You give 2 weeks to me because many matters will be clubbed on that.
Well,
They'll call this matter on 13/8. 13/8.
55.
Yes, Mr. Mishra.
So here the pleadings are complete. Here's the main matter.
It's a
Fix next week any date and dispose of the matter.
next week we have a difficulty. I will fix this matter on 13th August.
13th. 13th.
My difficulty is that there is an interim order pending against me.
Till then.
2013 is not far away. We are moving towards the destiny.
Interim order to continue and it will be disposed, main matter will be taken up.
Interim order to continue. We'll take on call this matter on 13 day. Heard.
Yes.
Item 67.
So, Your Honor, I am submitting on behalf of Utkal University opposite party number 2 and 3. I prayed for time to file the counter, sir.
Counter. Within what period you will find? Because those are
No, sir.
you seen another matter. I have levied cost of 5,000 rupees.
No, sir. No, sir. Sorry, sir. No, sir. Sorry, sir.
All this matter on 22nd of August 2025. And in the meanwhile, counter many may be filed, failing which right to file one stand forfeited.
Item 68. Wait, this. You also count on your files.
So it's not
No, my lord. 2024 matter, I have appeared on October, my lord. I have not filed, my lord. 1 week time may be given. Already it is drafted, and within 2 days we will.
in your matter we have levied the cost of 5,000.
Yes, my lord. Extra, my lord. 6,000.
6,000. So in this will make it 3,000.
My lord. Today, my lord. Yesterday only. Already drafted, my lord.
22nd.
My lord, interim order to be continued on.
What is there?
Yes, my lord, on 39/24.
Interim order to continue. In the meanwhile, counter anything may be filed, failing which right to file on stands forfeited.
Grateful. Item 59.
Mr. Mishra.
It's a grant of caste certificate where Your Lordship actually heard the matter and while issuing notice directed the government to file a counter affidavit. Why the matter should not be referred to the scrutiny committee, the purpose of examining whether I belong to Lohar caste
Community or not. In the light of Madhuri party.
Madhuri Patil.
Is there any scrutiny committee? You want
time to file counter.
At the request of the ASC matter on 22nd August. Just look into Madhuri Patil. 95 Supreme Court.
95 Supreme Court.
Supreme Court. 94.
That has also been confirmed in other decisions.
Levity Giri and so many, Chandra Kumar, S. Chandra, so many judges. Yes.
Item 70.
Yes, also.
70 also, my lord. I have to file counter, my lord. Already drafted, my lord.
The BDA.
2 weeks time may be given.
Who are the respondents?
The main contestant is the BDA. Opposite party number 2.
You appear for BDA?
Yes, my lord.
You will file counter in how many days?
My lord, already drafted. 1 week time may be given to 1 week time. Already drafted.
So we'll grant him 2 weeks.
Yes,
finally.
Yes, ma'am.
Finally, a period of 2 weeks is granted for filing the counter, if any, failing which right to file one stand forfeiting.
Right.
Solve this matter in the first week of September 2025.
It's a date, the name better. Any date?
Yeah.
Interim order to continue.
Interim order is there?
Yes, it is. 19/12/24. 19/12/24.
Item 71.
71. I don't know.
Item number 71, my lord, I'm from the petitioner, my lord. I prefer Mr. Janakanta Mahapatra, my lord. I prefer Passover, my lord.
Passover.
Counter, I think not file, my lord. I pray.
You want to file counter? Call in first week of September. Any interim order is there?
There is only one Passover or something. Actually,
Today is not possible. We have some.
He is informing me that he is argument. He will argue this matter.
Mr. J.K. Mahapatra.
Mr. Janakanta.
But your brother wants some time, na?
I'll counter.
You have to be kind to the government advocate also. We'll have
Kindly fix a date.
that. Next 21st August.
Let's do next.
21st. A request of Learned ASC who seeks leave to file the counter in the meanwhile. Okay.
Item 73.
May I please, Lordship. Lordship, last stated your Lordship directed for notices. So, Lordship, they are not filed counter till yet.
They have not filed counter.
Lordship.
Brother, what did you do?
State is not a party,
Lordship.
Central
It is
University.
for the respondent.
As for the OP number 3, my lord, the respondent is UGP. Here the impugned order is passed by the Central University of Odisha.
Lordship, main party is Central University.
Who appears for Central University?
Still appear for Central University, Mr. Sachidananda Das. Lordship, notices which already issued. Lordship.
Already issued.
Issued.
Steps have been taken.
Lordship.
But whether service has happened, brother, whether service has happened.
Not yet.
Not the await service.
Wait service.
Await service. Okay. Await service. Yeah. First immediately after service.
74. 74, my lord. On the second item, we have filed counter. And in the first item, we have almost filed, my lord, within a short time, my lord. The counter has been ready, my lord. Also, ready to intercession, my lord.
Learned ASC submits that the draft counter is ready and the same after finalization will be filed within 2 weeks.
Second application, my lord. Second application, my lord. I am for the petitioner.
For this petition.
In that case, we have filed counter.
Let you have filed the counter.
That is fine. That's copy of short, my lord. I have received
Contesting opposite party, my lords, because I am affected by that, my lord. So if the conditional list should be revised, I pray, my lord, the government counter should copy of it.
Yeah, counter you have to give to the.
Yes, my lord.
Counter should be shared with all the parties.
No, petitioner, we have sought, my lord.
So with all the parties.
I'll file this.
You can collect them on this matter in the first week of September.
Interim order, so for first item, my party.
Interim order is there.
second item in June.
Then second, third week of September. Interim order to continue. Yes.
Item 75.
This is a matter that is regarding backyard poultry, my lord, that chicks they have procured for PVTG, particularly vulnerable target group, SC/ST, backward communities. They have been supplied with 4 weeks old chicks, my lord, livestock cases. And the petitioner, who is before your lordship, is the only one MSME in the state of Orissa who produces chicks and has the capacity of 50,000 hatching, 50,000 eggs per day. Whole Orissa, he can give supply chicks to whole of Orissa.
You can make all Orissa people chicken eating.
That because, my lord, this why the policies are not being taken up carefully. That's why Orissa is so poor. My lord, and physically and economically. My lord, kindly have a glance to page 30, annexure 5. This is the CDVO report to the Director Animal Husbandry. What they did, my lord, in the Department of FARD, Fishery and Animal Husbandry, Veterinary Services Department, they have open tender. They have now, they don't float tender. They only registered all these MSME. I am the only producer, all are suppliers. They just purchase from Delhi, Andhra, and everywhere. They produce. They supply here in different district. Only one district they have allotted to me, Mayurbhanj. I have 25 acres of land, I have farm, everything. What happened when they have gave me order for, they passed the order to supply for Mayurbhanj. My lord, kindly have a glance to this. That what the MSME policy, how they have changed, my lord. Then kindly see that the letter, Annexure 9, my lord, page 50. That is to Messrs. Diamond Agrovet, supply of 4 weeks old LIT, low input technology chicks, and Isle and Sorangi, other defined variety chicks of 2nd week old ducklings. This is they have given me on 6/1/2025. Either you have to Isle or Sorangi bird. Sorangi is not a LIT bird. Still then I have no problem because I have to give Isle. Because they have kept one option of Sorangi. What they did on 1/3 March 1st, they have changed it. Second paragraph is very important. However, due to a decision by our higher authority, that is CDB, Annexure 10, page 52.
Continuation of.
However, due to a decision by our higher authority, that is the communication to me by the CDVO, Chief District Veterinary Officer, higher authority, High Director letter number such and such, you are requested to supply
Sorangi breed.
Sorangi. I am producer of imbue, and that is a LIT, low input technology barn. Sorangi is not a LIT barn because it is purchased from Delhi and the supplier will give on Sorangi. Then, my lord, thereafter, when I have come before this honorable court said there is no bar because you have already given 53B, my lord, kindly see that interim order, either L or Sorangi bars by the petitioner till the next date. My lord, in the meantime, they are giving order to one supplier.
You have interim order now?
No, now in this case, I have also interim order because my livestock, my lord, this is already 4 months past. There is no response from their side. My lord, my
interim order is to what effect?
Interim order, my lord, that
it stays 1/3/25 order, perhaps.
No, interim order is in this case, my lord, the present case, that the other supplier who has already given order of the Mayurbhanj will not be given effect to. Yes. Because I have only Mayurbhanj district, one of the district, tribal district, I got, my lord. Kindly see that I will make it clear, my lord, before your lordship, that...
Now you are arguing for what?
For that, I want to supply those because order was placed on me. And this is 4 weeks, docklings are ready to be supplied. Now this has been stated by this honorable court that no supplier can give no trader without changing.
Their supply is stopped now.
My lord.
But your supply, there is no order at all.
Now, they have supplied, my lord, kindly have a glance, page 54, Annexure 12. That is the input before your lordship. 54, page 54, Annexure 12. Series, my lord, there are 2 orders. Morsel Food Tech, who is at Badambadi, Cuttack, here near the bus stand. He is a supplier. Now they have given Mayurbhanj district order to him, the PBTG, particularly vulnerable tribal group blocks of Mayurbhanj. That is my order in the month of January. That has been given to a supplier. That was been stated by this honorable court. And he has, and the next page also, the other blocks, my lord.
They are also stayed.
They are stayed. But my prayer before your lordship, they are not able to file any counter. And he has supplied to some extent. I am not disputing that. But my chicks and ducklings are now ready. I may be allowed to supply. And he has given notice also, special messenger notice, and he is not appearing. In my lord, just 1 kilometer away.
But it's
4 weeks time is allowed to file count.
In the 4 weeks, they become, how can she hold all of them?
Yes, that's right.
Thousands of chicks are ready now.
23/4, my lord, notice issued. 23/4.
You accept supply. Subject to outcome, because even these letters have been stayed already.
Yes.
The supply orders have been stayed already.
Right.
Therefore, accept the supply of petitioner.
Petitioner, and that is subject to...
The people will eat them and they are exhausted. Nothing will happen.
Yes.
You can decide the matter in the course of time.
My lord.
All right.
My lord.
Learned counsel appearing for the petitioner vehemently submits that a coordinate bench of this court has made the interim order dated so and so, dated
23/4/2025.
25 as under. Next paragraph. She further, next paragraph. The net counsel further submits that already the shiks are ready for being supplied in terms of the earlier order. Which was that order which awarded contract?
50, page 50, my lord.
50, go to 50.
Page 50. To
In
petition.
terms of letter dated
1,
no,
no, 6/1.
6/1/2025, 25, and therefore the petitioner should be permitted to supply the same in terms thereof, and the official respondent should be directed to accept the supplies. First off, she also highlights the difficulty of holding the grown-up shik after a particular period. The first one. Next paragraph. Learned ASC appearing for the respondents seeks time to file the counter. He does not dispute that pursuant to interim order of the coordinate bench mentioned above, reproduced above, there is no supply from the other private respondents as yet, there being interdiction. First off, no prejudice should be caused to anyone if respondents are directed to accept the supply of the earmarked shik. Which is that? Which shik it is? They are which?
L.
Yeah?
That is LIT bar.
LIT.
LIT, low input technology bar. LIT L. That is
LIT brand.
bar.
Huh?
LIT bar, my lord. Low input technology bar.
Bird. Low input technology birds. In terms of letter dated.
Next 9, page 50. 6/1.
Letter dated 6/1/2025. A copy whereof will set annexure A9. First one. Ordered accordingly by way of interim measure. Okay. All right. You can supply now.
My lord, okay. Briefly, please.
77.
May I please, Lordship?
Yes.
Lordship, it's a demolition matter. Lordship, it's a demolition matter, Lordship. Perhaps it is not before your assigned bench, Lordship.
It's not for me. It is submitted at the bar that this matter is not within the assignment of this court, and therefore the registry had to reclassify it and post it before the roster bench.
Lordship, if I may, Lordship, SR has wrongly written it as OD Act under. It is demolition matter. So SR has made a mistake, Lordship. Lordship, there is
need to verify and post it before the appropriate bench.
Lordship, there's an interim order.
It's till then interim order to continue. Okay.
No, Lordship.
78.
May it please your lordship. My lord, very small matter, my lord. Notice was issued your lordship by 1 May 2025. Counter affidavit has not been filed, my lord. The short point, my lord, the petitioner has taken
5 days leave and 3 days are the government holidays. So total 8 days leave was action.
No pay, they say.
They say that UL, they have treated as a UL as per impugned order Annex 3, page 16. Even though I have 15 days CL in my account.
They have treated it as earned leave.
EOL,
extraordinary leave.
Extraordinary. When no leave is not in the account, then can only EOL can be sanctioned.
To EOL, if he has the store of his earned leaves.
15 days I have in my account.
Days.
And this is only deducting 8 days. Again, 7 days are in my account. But they have treated as a UL. UL means that cannot be calculated that without pay, and that cannot be counted, my lord. That is amounts to.
Brother, we will allow this petition.
Annex 3, page 16.
I'll counter, madam.
When will you file counter?
Another 4 weeks time.
But such a small matter. How can you go for UOL when he has so much credit?
Only first time it has come. And next
on
time
account of that, my increment has been withheld on account of that since last 3 years.
And this is the first time matter has come up.
May notice was issued.
Notice issued already.
Notice was already issued on 3rd May 2005 in the IS, also the writ, my lord. On fixing 28th July. Your lordship kindly see the order dated 3rd May 2025.
You have a copy of the petition?
Yes.
Lovely. ESC is granted 2 weeks for filing objections to counter. If any failing which right to file stands forfeited, call this matter on 14/8.
79. Lordship. My lord, children are before lordship doubting for a registration of the name in the school.
Pramati goes against you. My lord, Pramati. The decision of Supreme Court in Pramati,
yes.
Education Society, that goes against you. I examined again yesterday.
I have filed a short counter. Your lordship kindly see.
Have you brought that judgment?
I'm relying on a judgment of unaided private school of Rajasthan versus.
Supreme Court has said that Pramati. They have not brought that. Pramati Education Society versus so and so.
Yes, ma'am.
That there said the RT Act is not applicable to the minority aided and unaided institutions.
Yes, ma'am.
If that is so, where will you? How can you grant relief to you?
Because school has got the recognition. School has got the recognition from every part.
Still it.
Yes, my lord. This is the Pramati judgment I have not examined, but in any case, I have.
Which year it is?
My lord, 2012.
After that, law has traveled like anything.
Yeah. Your lordship may kindly have a glance of this. School has got recognition from.
That makes no sense. Well, every school has to have recognition and permission.
But the government has recommended the school to take admission in that school.
It cannot.
Because they are denying.
Apex Court say,
my lord,
Apex Court has considered this aspect under the RT. That is Pramati judgment.
This judgment is Society of for Unaided School of Rajasthan versus Union of India. The lordship may I just one para I have flag marked.
Yeah.
Kindly have a glance, my lord. Violating the government guidelines and notification, my lord, after the Right to Education Act, clearly violating. School has recommended their name. Registration has already settled. Petitioners are already there and registered their name.
Covered by judgment. No, there is the judgment of Apex Court itself.
3/4, para 20 is the conclusion, my lord. Your lordship may kindly see. May I place, my lord?
Anybody can find out Pramati versus Pramati Education Society. Union of India. Where that challenge. 2014. 2000?
Yeah, 2014, SC 2114.
2014.
Yes.
SC 114.
Yes.
Thank you. 2114. Petition is dismissed in view of decision of the apex court in Pramati Education Society versus Union of India, AR 2014 SC 2114, which held that the RTA Act is not applicable to both aided and unaided educational institutions founded and administered by minority religious minorities in under the provisions of Article 29 in history of Constitution of India. Next. Thank you so much.
Dismissed, my lord.
This
Because the petition.
yes. Supreme Court decision. We have dismissed it because of the Supreme Court decision.
Not on the previous occasion, the school has admitted the students, madam.
Previous school has admitted.
Admitted. But Supreme Court says RTA Act is not applicable to private, aided and unaided institutions.
The student's name has found place in registration list, my lord.
That apart, my lord.
If you go on asking
My lord,
what is I want to give relief actually.
the right of the child, my lord, they spoil the education of the children. What you see the notification and the guidelines? As I pray, my lord.
Next.
Item 80.
Yeah.
Last occasion, the Lordship has directed the state to take instruction regarding the deployment for 3 days.
Deployment of
3 days in a week. In interest of our Lordship, yes. That's
yes, brother. What do you say?
The counter has been filed.
Huh?
No, time to file counter.
The deployment order will stay. Why 3 days he should come and these 3 days he should go there? What is this exchange program? It will be troublesome to both of them.
yes.
Which is that?
The annexed to page 11.
2 months.
Till you are not filed objections.
No, I have not filed. I have time to file objection.
Learned ESC seeks time to file counter resisting the petition. First, the counsel for the petitioner submits that the impugned order at Annexure 2 dated 2/7/2025 works tremendous hardship to his client, and if that is stayed, no prejudice will be caused to anyone. First up, there is force in this submission. Next paragraph. In view of the above, the impugned order dated 2/7/2025 at Annexure A2 is stayed till next date of hearing.
May I play? They have altered arrangement is there. Government has already taken Item 79.
79?
Government has already arranged my
Student to the nearby school for admission of these students, my lord.
Then this petition will say it has become infectious.
Yes, my lord. Lordship kindly have those time we received the instruction, my lord. Then Lordship kindly refer the same orders of the
Learned ASC, this petition has become infectious in as much as Learned ASC submits that alternative school is arranged. Admission for the petitioners is arranged in the alternate schools, and therefore petition be disposed of.
by what's your letter number?
By letter dated,
page 7, my lord.
Director
Issued by the Director of Education related today, my lord. 31/7/2025. In the last
Why letter dated really there? Where is that?
page 7, my lord.
It's 7.
Page 7,
You are right.
Blanche, my lord. To the Block Education Officer, Bhubaneswar, District Khurda,
Why
admission of students of EWS and
letter dated 31/7/2025, a copy whereof is produced as Annexure 4
of the instruction matter.
of the
Instruction issued by the
issued by the
DEO Khurda, my lord.
Director, Elementary Education, Odisha. First off, the same reads as well. Next paragraph. In view of the above, petition is disposed of as having become infectious.
I beg pardon, my lord, item 80.
I may allow to admit to present petition on that school because
They have given the schools they have given.
We have to take it.
I beg pardon. I beg pardon, my lord.
Yes.
One more submission in item 80. Let the headmaster be directed to allow me to continue.
The headmaster of which school?
Of the Chintamani Government High School.
The headmaster of Chintamani Government High School is directed to permit the petitioner to work in the same school. Same school.
date will be fixed. Date will be fixed
For this matter in second week of September.
Yes.